Should be live. Yeah, you're live.
Okay, start calling the cases.
Yeah.
Okay, good morning. This is the New York City Board of Standards and Appeals Public Review Session for August 10th, 2020, 10 a.m. session. No public testimony during review session. The following items are to be adjourned. 6414BZ, 1320 East 21st Street, East 23rd Street, Brooklyn. 2019 195A 191 Industrial Loop, Staten Island. 2016 4463BZ, 6202 14th Avenue. 2019 16BZ, 25001 Northern Boulevard, Queens. 2019 35BZ, 235 Beaumont Street, Brooklyn. 2019 68A, 235 Industrial Loop, and the following cases postponed. 2018 124BZ, 2130 Broadway, Manhattan. Decision items, item number, whatever it is, 9, sorry. 6797BZ, 210 East 86th Street, Manhattan.
Item number 8.
I
8,
think,
I'm sorry,
yeah, okay.
I'm sorry.
That's all right. No submission was required on this and I don't see any
8, yes, sorry.
conditions. So I would like to make a motion to grant.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Item number 9, 8599BZ, 1106 Metcalf Avenue, the Bronx.
No submission was required on this, though we did get photographs showing that the banners had been removed that had been revealed in a prior submission. I think there was a lot of sort of internal confusion about whether we were supposed to get drawings on to show the landscaping, but the existing drawings show proper amount of landscaping. It's just that at the site, there isn't an adequate amount of landscaping as reflected on the drawing. So what we talked about the last time was a conditional approval, a conditional grant, where the condition, and so I'll go through that first condition. The condition is that the landscaping, as shown on the drawings, on the approved drawings, be installed pursuant to the approved plans and installed by the spring of 2021. And that our compliance officer, so Ted, please note this, to note on his calendar to do an inspection in late May of 2021 to see that the work has been done, and failure to do that could result in us calling a compliance hearing. Further condition, did everybody, does that sound consistent with what we talked about? Okay, then there were this was a problematic site, and so one of the reasons that we agreed to this condition is that the owner, after many hearings, kind of stepped up and made a lot of changes. So we see good faith, and it's a difficult time to get work done. So further conditions are that the asphalt fencing and acoustical fencing and walls and landscaping be maintained at all times in good condition and repaired and replaced as needed. That the site be kept clear of debris at all times because we had a lot of trash stored on the site. That the dumpsters are to be kept in the trash enclosure area at all times. That there be a minimum of 4 times a week pickup of trash. There had been only 2 times, which apparently wasn't enough. That no storage of chemical drums be permitted on site because we had some toxic drums on site. That lighting must be directed away from the adjacent properties with 0 lighting spread on the adjacent residential lots, and that the signage must comply with the C1 signage regulations. Anybody, any other conditions anybody has? And if so, please speak up. Okay, so I'd like then, based on that, a motion to grant, and Commissioner Sheta, can't hear you, you're muted.
Oh, sorry. No,
Okay.
I'm not. I'm not muted.
Okay, so what?
Yeah. The parking. we said we can discuss imposing a condition on the parking because of the cars that we found parking in the first pay towards the fence during my site visit. You want to put that in?
So, okay, so what I remember was Commissioner Otley Brown didn't see parking on her Sunday visit. You said that you saw 4 to 5 cars parking between the fence and the easternmost 2 pumps, and then subsequent visit by Commissioner Otley Brown, she didn't see that. So we can make it a condition. I'm not really sure what the condition would be. What would the condition be?
Maybe a condition regarding the non-authorized parking on site.
But what is, no, it needs to be more specific. So they're allowed to park whatever the number of cars is. They have parking bays, right? So you're just we're noting cars parked in a place that's not normally striped. I mean, the only thing I can think of is that there should be no parking outside of the striped areas. Is that what you're?
Yeah, something like that.
Are people okay with that? Okay, well, anybody have an objection to, I can't hear anybody speak, so say whether you're okay or you're not okay. So it would be no parking outside of the striped areas, but I do have to say that that's why we striped the areas, to indicate where the parking is. It's a little bit redundant, right? It's a way for us to control the spaces. Commissioner Otley Brown, did you want to say something?
I wanted to say I wasn't sure how that would be enforced because, yeah, I think I know what the commissioner is getting at. I think you don't want them to be leasing parking space in this, at this site. Is that what you're trying to get at?
Kind of. I don't know what they're gonna do. I'm not sure even why the cars were parked there. I went there on a weekday. I found like 5 cars parking next to the fence in one of the pumps base. So I'm not sure whether these cars are leasing parking, whether they are owned by people who work for the state. I have no clue. But I saw these cars. I even submitted pictures to the record for these cars. So if we want to like alert them, we could put it like verbally to not do it. But if we want to enforce it, I believe we should say it in the resolution that
Right,
no
but don't
parking,
do what?
no
So I think
parking
no parking.
on locations other than
Right.
specified for parking, period.
The striped areas,
Yeah.
specify,
Right.
because this is a striped lot.
I understand, but I personally think you're going to run into trouble because when people go to gas stations, they pull into the pump, they'll run in, pay for, I want $20 worth of gas. They come out. Sometimes they only use $15 worth of gas. They leave the car at the pump. They run back in. All right, give me back my $5. Or sometimes they run back in and go, you know what? I want a soda and a coffee also. And they go and they buy that. So I'm not sure how you would be able to enforce the no parking unless you're in the stripes when there are people, it's the nature of the business that people just leave their car at the pumps anyway, and they're turned off and they'll run in and run out. And it would be very hard to me for the applicant's employees to constantly be like, don't leave your car at the pump. So I understand that maybe the commissioner wants to prevent long-term parking at the site. And that I could see as a condition if you specify long-term parking, perhaps.
What does long-term mean? How do you define that?
When right, that's the question, because I think you don't want people to leave the car and go to work and come back 7 hours later, or leave the car overnight. That you don't want. But I'm going to leave the car for 10 minutes while I go in and get the this, and this that I want and wait online, that you can't prevent.
Right.
I don't think the kind of cars I saw on site were like for short term or for somebody who's grabbing. Actually, I parked my car outside and I walked the side. I took like 10 minutes walking around. And after that, I went even to McDonald's, got coffee and came back. And the cars, when I looked at them, the cars were like, they were there for a while. So that's what I'm talking about. If somebody is gonna leave his car, it's not gonna be an enforcement officer waiting to that guy to watch him and see whether he's going to get a coffee or he's going to get a work. So I'm not talking about 15 minutes or even half an hour for somebody who's leaving his car there. I'm talking about 6 people or 5 people who left their cars in like a row. It was like a parking lot.
Okay, so let's just call it long-term parking.
Right.
And say, no long-term parking is permitted on the site in the first place. So that's easy, right? So then we don't have to be specific about where. How about that?
That's a great idea.
Commissioner Otley, Commissioner Shonda has her hand up.
No, I was just going to add that this site is not very big to accommodate too much of parking spaces anyway. And also in the past, or from the photos submitted by the applicant and from various site visits, apart from the site visit the commissioner made, I don't think that issue of long-term parking has ever come up.
Well, so it was observed. So, and it's not a big issue, right? If you can't have long-term parking on this site anyway.
Right.
So it doesn't matter where it is, in front of the convenience store or up against a fence, it's not allowed. So it's not, they're not giving up anything that they had. Right. And so that clarifies it, at least that way, if we have complaints in the future, we can say you weren't allowed to rent this as a long-term parking lot. Right. So, okay, so then thank you, commissioners. That was helpful. So let's go for motion to grant on all of those conditions.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
Item number 10, 2018-67BZ, 7406 Fifth Avenue, Brooklyn.
Okay, we did receive the DOB approved sprinkler drawings. We received proof of payment of the ECB violations, and a note on the drawings as requested was also provided. So I don't think there were any conditions on this. So I'd like to make a motion to grant.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Continued hearing items. Item number 11, 5106BZ, 18802 Union Turnpike, Queens.
This is a review session, so no testimony is accepted during this time. Okay, a very detailed sign analysis with drawings was provided that separates the different establishments at the site from the 2 that are the subject of the variance. Thank you for doing that. A brief statement of potential loss was provided as well. Didn't go into much detail, but basically said it would be really tough if we didn't have use of the cellar, because it's hard to rent cellar space, and someday they'll actually be able to open to use these facilities. So I was okay with it. Any other comments from anybody?
Yeah, I didn't have actually, there's only one minor correction. Since we are going to, if we do close, we won't vote it out. So the only correction is that the side elevation along 188th Street and 189th Street were mislabeled.
In what way? They wrong streets?
Yeah, so they showed where the elevation of 188th Street was shown, it was labeled as 189th, and 189th was labeled as there. So it's just a correction. And because it deals with the signage, that's why I'm just saying maybe that can be revised and it can be submitted and we can vote on it. I did not have any issues. So I'm okay with it, and I'll be okay to close it.
Okay, great. Any other comments from anybody? Okay, good.
Item number 12, 34312BZ, 570 East 21st Street, Brooklyn, and we have to update the lineup with the new firm name next time.
Yes, and we did get a owner's authorization. Slater and Beckerman were merged with another firm. So, but we did get owner's authorization. Sorry, I just want to make sure I'm in the right place here. So we last heard this in October with 2 adjournments since. One was COVID related to allow a better chance for the community participation, believing even then I thought overly optimistically that by mid-August we might be back to in-person hearings. We received 31 letters opposed to the adjournments in February and April. And given the amount of community opposition and the need to understand how to participate on Zoom calls, I really think this hearing should have been renoticed. So if we have subsequent hearings, we should have that hearing noticed because the Zoom hearings require special instructions. However, we did receive 2 letters from opposition dated mid-July. So apparently that person or persons were aware of the hearing. We have a community board conditional recommendation that's dated from November 6, 2019, which postdates the last hearing in October, with 9 opposed and 2 abstaining. I'll just read briefly what it says. It says recommend approval for 2 years following BSA's approval, should BSA so approve. This recommendation is also contingent on there being no changes in the application, including identity of the applicant, primary use of and determination. Yeah, no, I know. Sorry. Primary use of and determination that the facility is a school, and architectural plans presented to Community Board 14 originally needs to comply with those. Should any of these changes occur, Community Board 14 rescinds its recommendation for approval. Opposition letters from late January include photos of debris on the site, which the letter writer describes as medical waste. Additional written testimony was submitted to support the contention that the facility as now proposed is not a school entitled to deference under the Cornell Doctrine. At the last hearing, we asked the applicant to respond to these types of claims by opposition. The last submission by the applicant is March 20th in preparation for the April 7th hearing that we adjourned. By that point, we had only started to learn how to handle the Zoom meetings, Zoom hearings, and we thought it best to postpone that hearing to permit better community participation. I'm saying that for the benefit of any of the community who may be listening on this YouTube video. That's why we postponed or adjourned that hearing. The March 20th submission is from different counsel than had been the original applicant's representatives on this case, and we requested and received a new owner's authorization to hear it. It's actually the same physical lawyers, but that law firm was merged into another a larger law firm. Opposition raises the question about the actual use of the site as a legitimate school use. The applicant has to walk us through and explain submissions by opposition. In other words, address those submissions. In the March 20th submission, we learned that there is an owner, a fee owner of the property, Kolel Beis Yaakov LLC, and a contract vendee known as Ocean Avenue Education Support, the latter of which is intending to lease the site to the Brooklyn School for the Medically Frail. The property is somehow being used as collateral to support a construction loan to another entity, Dittold Associates LLC, in connection with a property across the street that is leased by Dittold to Ditmas Park Rehab and Care Center. What we also learned is that the purchase by Ocean Avenue Education Support cannot take place until the Brooklyn School obtains per pupil reimbursable tuition rate approval from New York State Education Department. This last information is also what we heard in October. And I have to admit that I haven't heard that kind of an explanation given for school development that I've been exposed to so far, that they have to wait for tuition approval. And I know that this is a special needs school, and so there's a reimbursement element of not sending your kid to public school. You get reimbursed to send them to private school effectively. But we have looked at special needs schools, actually quite a lot of them, and that was never an issue. And I think in part because those special needs schools have existed for a long time. So when we look at applications for school variances, we ask for proof that the entity that will be the beneficiary of the variance is a recognized school. For the information of opposition, so I just want to put this in perspective, we sometimes do have applications for variances for schools where the site owner, the owner of the land, is not a school, but the net lessee of the land is a school. And just to name a few, the Alvin Ailey Dance Foundation, Memorial Hospital for Cancer and Allied Diseases, Pace University, all of those are lessees. So it's not unusual for us to grant to lessees when the lessee will own the building or occupy the entirety of the building and it's built for their purposes. The way it sounds from here, the requested variance to me really was premature, since we have no demonstration whatsoever that the school could ever be built given the chicken versus egg conditions. The school needs the per pupil analysis, reimbursement analysis, to be able to get a loan to buy the property and to get a construction loan. They need the grant to, it's not really clear which, get the per pupil analysis. And they also need a certificate of occupancy to get the per pupil analysis, but they won't be able to get the certificate of occupancy because they don't have the loan to buy the property or to lease the property, et cetera, and to do the construction. So without the per pupil analysis, they're nowhere from, and that comes from the Board of Education. So we asked that same question months ago. The grant itself was years ago. And I'd like to know, and we don't have, where the hard demonstration is that the entity, in other words, the Brooklyn School, has been approved by the New York State Education Department the way charter and private schools demonstrate to us with a copy of their actual school charter. They all end up getting a charter. They give us a copy of the charter to show that they're a legitimate school. Schools start up somehow and get approval somehow to operate their initial school without having a school building in hand. Many just rent the space to start with, as was demonstrated by the applicant in this last submission, as did the Strive Right School for more than 10 years after becoming a registered not-for-profit and before owning their own building. And so as far as I can tell, the Brooklyn School is not yet registered with New York State as a not-for-profit education corporation. And I did look up on the New York State corporation site where you can search the names of entities, and I found it nowhere. Whereas I did find Strive Right, and I found Strive Right listed as a not-for-profit on the IRS also has a website for not-for-profits. So, and with no operating history, the school cannot persuade New York State Education Department that it will operate a certifiable school. The proposal now seems to be to operate the school in another building. I'd like to know what the status of this is. Why has the applicant waited so long to learn the process needed? They indicate that they hired consultants who knew better than their first consultants in 2017. So it's been over 2 years, maybe almost 3 years. why did it take so long to figure this out? And how long really before the temporary school can move into the now in development location across the street. So that building isn't even finished. So they need to wait till it's finished, wait till it's outfitted for the school use, and then occupy it, right? And how many years before its existence is adequate to prove to the New York State Education Department that this is a viable entity deserving of certification and funding. So they have to establish themselves somehow or other as a school to be able to open as a school, even in that temporary location. And then they need to establish further, after being in operation for a while, that the school is worthy of additional support from the education department. And we actually have had experience with, I can think of one of the daycare centers that was this huge daycare center that came to us for, maybe it was a 7319. And it turns out that the state education department did not renew their charter. So that application to us was abandoned by that school, and another school stepped in to take over that space. We were told in March that the applications for curriculum approval by New York State Education are almost ready. I'd like to understand what the status is today of that. That's 5 months later. And I do understand that there have been COVID delays, but a lot of government agencies have been functioning during this. And also, why are the applications only now being prepared as opposed to soon after the initial grant? We're also being told that the Brooklyn School has, quote, obtained a provisional charter and certificate of existence, I think, from New York State Education Department. I didn't find that material in any of the documents. We have many documents, so it's quite difficult to find things, but I didn't see that submitted. And also, where is the hard commitment recorded against the property or otherwise that commits the current property fee owner to sell to the contract vendee and the contract vendee to lease to the Brooklyn School? And so, you know, the only way that I can actually see this grant continuing to work is if it were to this particular Brooklyn school exclusively, to develop on this subject site alone, and that the grant does not run with the land so that another school can step in somehow because the programmatic needs were very specific. And on condition that the Brooklyn School produces New York State Education Department charter approval, and that the program as described in the initial grant and the approved plans do not change without coming back to the BSA for a review. But it seems to me, based on what we're reading, they won't be able to take advantage of this grant for years and years and years. And I have to say, I'm sympathetic to the need for the school such as this one. It's really a very unusual class of students that are obviously deprived of normal education. The project, if I remember correctly, was really well designed. It was a very sympathetically designed building that took into account the difference in character between one street frontage and the other street frontage. So the two frontages were treated really differently. So in the realm of design quality, it's really up there in terms of what we normally see at the BSA. You know, I wouldn't want, and they went through a lot in order to get there. So I am sympathetic to what they went through to get this initial approval. But now, as we learn more, it seems like the application was extremely premature, or maybe they didn't realize how actually half-baked their idea was. And I do have to say that if they do open the temporary school in the new building, they may discover that this is, you know, it's a very challenged student population. They may discover that with only 5 classrooms in that other building, which has all the facilities arguably that the kids need, that that's good enough, and that they won't need to come back because they've actually found between a rehab center and the school facility for these very disabled kids. And then I just have to say, there are 3 open ECB violations, although no fines are due on that site. And I'd like to understand what the status is of the cure for the presence of illegal parking on the lot, shipping containers, and industrial machines on the lot, as were observed by the ECB or by the inspectors in September 2019. And now I understand that site's being used as staging somehow for the building that's under construction across the street. So sorry for the long-winded response, Commissioner Shanda.
Okay, thank you. Thank you. Hello?
Yeah, go ahead.
Okay, I heard an echo, so I wasn't sure. The March submission that the applicant had provided, I thought was very informative in terms of identifying the complex set of steps that a new school establishment has to undergo, which, as you pointed out, Madam Chair, typically we don't have to see that because most of the applications are from established schools. And so this is a new issue that we are facing. And the applicant, again, I would like the applicant to clarify why did they proceed with the BSA application so far ahead? Was it something that they required in order for them? They thought it was a simple process. They needed the approval to show that they have all the necessary approval and then secured the financial grant. And then along the way, I think they may have, as you pointed out, discovered that the process is not as simple. It has to go through a temporary they have to establish themselves in order for them to even get through the first step. I think the opposition letters, they mentioned a lot of issues with regards to hospital waste and other things, and that such a news would result in biohazards and other things. I really didn't. There is an issue of keeping the site clean and clear, and making sure that the site has been secured. And the applicant, in its last photo that they submitted, showed that they have removed the container and they've cleared the site of all the various debris and waste that were there. So I do want to make sure that the applicant, should we go ahead with this application, that I want the applicant to make sure that they will continue to keep the site secured and clear of all debris, waste of any nature, any kind, and prevent any illegal dumping of any sort on the site also. I mean, in terms of medical waste, as I was reading those comments, what I was thinking is that use group 4 hospital would be permitted. So we have to keep that in mind. And what this is, we don't know what kind of waste it was, but regardless of whatever waste it was, the applicant is responsible for making sure that the site is always clear of any waste debris and is not a hazard to the neighborhood. So I would like the applicant to kind of clarify, why did they go through the process of BSA first, and what were they thinking then? And I was reviewing the BSA resolution from the initial grant, and in that it says the Brooklyn School for Mentally Frail Children is a nonprofit education institution chartered by the Board of Regents of the state of New York. So, hello?
Yeah,
Hello?
medically frail. You can't hear us?
It's breaking up, so that's why I just want to make sure, because my connection is fine. So, yeah, so based on that, I assumed it had the approval from the New York State as a nonprofit education institution charter, but if they could provide a document for our record, that would be helpful. And as you mentioned, I would like to know the status of the temporary site, where they are. what is their timeline? Because I don't think they will be able to achieve what they're proposing to achieve in a 2 years time period. So they need to give us a more realistic timeline of how they're planning to achieve their final destination of being able to start the construction.
Okay, thank you. Commissioner Otley Brown?
I was happy to see that the trailers were removed from the site. And I'm very sympathetic to this school. I remember the first time it came around, there clearly is a need for this type of educational facility for young people who are very vulnerable physically. That being said, I don't want this to be stretched out into infinity in terms of time before they finally get started. I would love to see some forward motion on this site because the variance was for this site. And so if they could give us a more detailed report on what they intend to accomplish at this site and when, that would be very helpful, and it would signify that they're more serious about moving forward in the immediate future.
Okay, thank you. Commissioner Sheta?
Thank you, Chair. I'm not going to be repetitive, but first of all, I want to mention that there was a submission on August 7th. I'm not sure if everybody saw that. It was, I believe it was from the opposition side.
Yeah.
And it came, I couldn't see actually the picture with the, what they call the medical waste at the first place, but in the first submission, in the January submission. But when this submission came in, I saw that picture and I understand their concerns about the stuff placed on site. I do believe that they look like they are medical waste. And I just want to be clear here that the concern from the opposition is not that simple. They believe that this is not going to be a school, and we have to make sure that this is incorrect before we grant an extension to this project. So I would like the applicant to respond to all the, I call them claims for now, the claims made by the opposition, and explain to us how either these are incorrect or what kind of actions they are taking to move forward with this project. Of course, if I believe, including me, everybody on this board is in favor of the project, but we're in favor of the public too. And if there was something that wasn't correct with the previous application, we should consider that with the 2005 application. The first comment I have is in their submission, the applicant indicated that Brooklyn School will lease the site. This is the school that will lease the site ultimately and use it. And I would like the applicant to confirm that this is the same school that was indicated in the 2005 application. Have they applied for any loans so far to date? Have they applied for any loans? Because the fact that they are saying that we cannot apply even apply for a loan, it's not possible until they get like the determination on the tuition rate. That bothers me because they are thinking about, and I'm using their exact words, circumventing the rules by like somebody else did before. So they want to circumvent by operating 5 classes or so somewhere else nearby. And I'm not sure if they can do that without having the tuition rate determined. If they need that tuition rate to be determined, so what is the point here? I need an answer to that. Next point is when did the consent from the property owner to the other owner across the street to use this property as collateral or security happen? Did it happen before the 2005 grant? And if it did, were the board made aware of that consent in the process of looking at the previous application, the 2005 application. So they need to answer this as well. And of course, in their submission, they confirmed that the property is already used as a security. They also mentioned something such as a overlap between the managing board for the school and the managing board for the other property that use the subject property as collateral. I would like them to explain clearly how much overlap. Is it the same owner? And what is the impact of the subject property being used as a collateral, or the consequences of this on the ability of the owner of the subject property to either sell it or even obtain a loan on it? My understanding, if I have a lien on a property or it's used as security, I cannot go to a bank and get financing using that. So if the property is currently used as a lien or as a security or collateral, and this is gonna last for, let's say, 5 years from now, are they gonna be able to start within 5 years? That's not clear to me. What else? Yeah, have they submitted an application to the New York State Education to obtain the tuition rate? I'm not sure whether this was done or not. All what I read is it's not finished yet, but whether this is initiated or not, this is not clear. And if it's initiated, what is the status? And please give us correspondences that you exchanged with the New York State Education in attempt to get the tuition rate issue resolved. Had an application presented, had the applicant presented any evidence of a Board of Regents charter as a school to the BSA in 2005? I want to understand whether they presented to us back in 2005 any evidence of being chartered by the Board of Education of the state. And finally, we've received a letter from the, I believe, the financing broker or the broker of the applicant, indicating that they cannot obtain a loan until they get the tuition rate issue resolved. My question is, have they applied and the application was denied? Thank you.
Thank you. Just a couple of things. There was a document that submitted by opposition, but maybe you want it from the applicant, talking about what the overlap is between the board members. They actually say this person's on that board and this person's on that board. My understanding also is that a collateral is a severe cloud on title. You can't deliver title free and clear if it's already committed to a mortgage, right? You're supposed to satisfy the mortgage before you sell it. Otherwise, the purchaser is now subject to the same mortgage. This is effectively a mortgage on the property held by the bank who's loaning construction money to that rehab center.
That's my concern. They are asking us for an extension. Let's say they are asking for 2-year extension, and the age, the term of the other mortgage that this property is being used as security on, let's say it's 10 years. So if it's 10 years and it's being used as security, actually this extension is useless, because they're gonna need 5 more extensions before they start construction. If they are willing to start construction with a financing like money, if they want to start out of pocket, if they have the money ready to go, they should have gone like with the construction long time ago. But if they are waiting for a loan, and the term for the loan that's this property securing is 10 years, they have to wait 10 years.
Mm-hmm.
So it's kind of a dilemma for me.
Yeah. Okay, thank you. And Commissioner Shedd, I see your hand up, Commissioner Shanda, but don't speak yet because we need to wait for Commissioner Shedd. I mean, Shabeta, sorry, Shabeta. So
Thank
many
you, Chair.
shoulds.
I share the sympathies of my colleagues with regard to the mission of this applicant. That being said, the submission does not leave me confident that this is going to be something that's going to get done. The catch-22 seems to be something, as they quote, their catch-22 seems to be something that's going to be a circular argument forever. I don't see any way how they're going to get from point A to point B. But that leaves me with another concern, and that concern is with regard to the statements made by the members of the community with regard to the site conditions. And while I understand they removed the shipping containers, the community members have complained about woeful conditions at that site. So I hope that today they can come and show us a clear line, but I'm not very confident that that's something that they'll be able to do. And that leaves us with the problem of how are we going to make sure that the premise remains in a clean and condition for the neighbors.
Thank you. Commissioner Shanda, did you have something you wanted to add?
Yeah, I think we all seem to be, from what I'm hearing, we all seem to understand that this project is a worthy project in terms of the need and that it is going to, the population that it's going to serve, it's a needed service, and it's a unique kind of service, and we are all sympathetic to the design. It was a very carefully thought out design. The challenge that is before us, that when it was granted, we thought it would happen within a certain time period. And now we are recognizing that the time period for such construction is going to be much lengthier. And though we are allowed to grant only a 2-year extension, this is probably not going to happen in 2 years. So my question to the board is that, should we do more of a phased kind of approval that within certain, should we go down that road? Should we kind of ask for benchmark of deliverables for every time period so that at least it keeps them on their toes to achieve the necessary approval that they need to get to where they are and provide this much needed service?
Mm-hmm.
It's a question that I'm just throwing out there.
Right. So I think, and it's a fair proposition. I think that the applicant may really need to sit down and do some serious soul searching at this point, because it seems like they only fairly when I read kind of between and under the lines, I used to represent, as a land use lawyer, what I used to call the lost puppies. And those were the not-for-profits, existing not-for-profits, who wanted to do a development and realized very late in the story that they had no idea how to do it. And so all of a sudden someone would say, why don't you hire a lawyer? And they're like, oh, we thought we could handle this with our board of directors ourselves. And so then after, 3 years trying, the board of directors, who are volunteers, can't figure it out because they are volunteers and they're doing other things for a living. And so finally they say, hire a lawyer. And then they're like, lawyer, can't you take care of everything now going forward? And then we'll just hire contractors. And then I realized that they're lost puppies and that they need development consultants. And so there are actually people called development consultants who work with not-for-profits who have no idea how to develop a project, right? So it seems like what's been going on is when this group came to us initially, they were unbeknownst to us, because they sounded very knowledgeable about the specific subject of the needs for these kids, right? They were actually lost puppies with no idea how you start a school, how you build a building, and all of that. And in the time in between, because they're all volunteers, they didn't really focus on this. And until sort of deadline for renewal sort of started to raise its head, they realized, uh-oh, maybe we're lost puppies and we should hire a lawyer or a consultant. And so slowly, those things are coming into play. But I think that without sitting down with the consultant and being told what's the reality here. The reality is, just as we learned from that Strive Right school example, they were open for 10 whole years as a not-for-profit educational institution before they decided to now move to build a building. These guys are going to need to do the same. They have to establish themselves as a viable educational institution. Many of these beginning institutions don't succeed, right? So that's part of it. So, you know, I love the idea of having them meet certain criteria over time periods, but without having a knowledgeable consultant telling us the reality of how it works for a school to be developed. And this is a school that does something that no other school does apparently in the country, right? So it's uncharted territory, so to speak, right? So it's a big task that the council and the consultants really need to respond to. I don't think the school management has the skill set to do that. Commissioner Sheta?
Yeah, thank you, Chair. I believe we're looking at two extremely different pictures here. One is painted by the applicant, the other one is painted by the opposition. The applicant saying, kind of, we were naive, we didn't know the process is that complicated, so we're stuck. Understood. On the other side, the opposition is likely saying, this is not going to be a school, this is going to be a part of a medical center or so. For me, two key points are the following. Number one, using this property as a collateral or security. Did it happen before the grant, the 2015 grant, or after the 2015? If it happened after the 2015 grant, for me, this is a turning point for the applicant, as they are just forgetting about that project. And this is not a good sign for them. The other thing is, they provided a letter from HHC Capital Advisory. It's kind of maybe a financing broker or something, mortgage broker. And they are saying we're approached by the applicant to arrange for financing, and it's not possible until they get such and such. When did this approaching process happen? Did it happen close 2015 or after that, like last week? If it did happen within the past 3 months, that's another sign for me that this project is not going to happen.
Thank you. And I just want to add one other thing, because in my experience as a lost puppy representative, I also at the same time represented schools that were even schools that were really knowledgeable and say had on their board members who were developers, major big time construction companies and so on. So they knew exactly how to build their buildings, right? But they fundraised from their own constituents, from their classes. And in one case, they needed $43 million of a school for the school to build a building. They earned it in 4 months. And it wasn't from loans. It was from donations from alum, parents, etc. Right? So that's the other part I find strange. Whenever I think about schools that are building additions and things like that, true, they get loans from banks, but the banks don't just require them to have like a tuition schedule. The banks say, we need to know that you have a constituency that is willing to support your project. So we need to see at least, say, 50% of the funding coming from parents. So it seems to me that's the other element in here. The school doesn't exist, right? So you don't have parents who are going to contribute to a school that doesn't exist, but you might have parents who want something like this for their kids and would contribute to the capital campaign if there had been a capital finance approach. But it doesn't sound like there was any capital pursuit in any way. You don't just go to a bank and say, loan me $45 million so I can build my school. You actually have to show them that you have other sources to make this a viable project. Because by the way, you also have to pay the mortgage. So, et cetera. Anyway. Okay, thank you, everyone. Any last minute comments? Okay, thank you.
Item number 13, 33279BZ, 43-20 Little Neck Parkway, Queens.
All right. The applicant requested an adjournment on this, but in collaboration with staff, we denied the request because that would make the 5th adjournment since December 2018. And a dismissal notice was sent out after the 3rd adjournment in October of 2019. And the February adjournment predated actually the COVID crisis. So we can't even say COVID was the cause of the adjournments. So I would like to discuss dismissing this case entirely, but it is for an extension of term. So, you know, we tread carefully where we've got existing businesses. So it's after 1.5 years of adjournments and 2 years since the initial filing. There has been more than enough time to show us photos of work in place that was promised. We can't use COVID as an excuse for 1 year of adjournments and delayed work. In 2018, we had many issues, 0 of which have been addressed in submissions. Estimates and invoices were submitted with this most recent submission when we, I think it was submitted with the submission requesting the adjournment. They show first engagements only since February 2020. So what was going on all the way up until then, and for architectural services, 1 test pit boring and perk test actually done and was billed for, and that was only done in June, and estimates only for paving, fencing, and lighting in which were provided in February and June. So I alerted our project manager to alert the property owner that he or she must appear at this hearing, because the only way we seem to get response from unresponsive applicants is when the owner attends the hearings. So the owner must attend any hearing that we have with this, assuming we don't dismiss it today, but to give the owner a chance to understand what it's exposed to here. So other comments?
Yeah. You know, I went to the site again recently, and what I realized that this is an unusually huge site as a space for parking lot. We typically don't see such huge sites for parking lot where we typically see gas stations or a parking lot associated with a small strip mall. So the square footage that these facilities have to maintain and take care of, it's in 7,000, maximum 10,000 square feet. This one is over 45,000 square feet of a space that needs to be landscaped. It has a huge area that needs to be landscape buffered. Already there are a lot of trees and bushes, fencing, a huge area of asphalt. And the owner had stated at the last hearing that this was back in February that they do not have enough adequate rent roll to secure the necessary construction cost or even the financing and other things. And I'm sure now, when I was there last time, I really didn't see any of this. I only saw 1 or 2 stores open. None of the others were open. So it's probably facing even harder time than it did back in February. So I am very sympathetic towards this case. I really am not that comfortable suggesting dismissing it, because this is an unusually large site with a huge cost undertaking, which is not typically we see of applicants with parking lots where accessory to a shopping center. So I'm more in the line of allowing for a conditional approval with very phased, again, similar to the previous one, providing a phased timeline of deliverables that is realistic and meet those in a manner that we can monitor and try to continue with with that. And that is what I thought of when I went to the site recently, and given the current economic state and conditions that we are all facing.
Commissioner Otley-Brown?
I tend to lean more towards the chair's opinion in this case. This case was last heard, I believe, December 2018, which means that it's over a year and 8 months since the last time we heard this case. And there's been no communication on the part of the applicant as to why they keep adjourning over and over again. There's no request for us to work with them because they're having financial issues. It's just adjournment after adjournment after adjournment. So I don't know necessarily that they need all this special consideration, because they haven't given the board much special consideration.
Thank you. Okay, Commissioner Sheta?
Thank you, Chair. I agree with both of you and Commissioner Otley-Brown. I haven't seen enough communications from the applicant that indicates that they're going to be moving forward. And I'm willing first to listen to them today, see what they're going to say. But I don't think the kind of proposals and the invoicing for the infiltration test and the one-bore infiltration test and a boring could be done in probably as little as probably 4 hours, half a day. So it's not a big deal to perform one boring or two borings, or one day of drilling, same day you do the infiltration test. So I will need to hear from them what is the reason for adjournment so far.
Mm-hmm. I believe the perk test was already done. That was the only thing.
Yeah. I saw that.
Yeah, so they got a bill for, I don't remember, $4,000 or something for the perk test. So
what I'm saying is,
yeah.
I'm sorry, go ahead.
Sorry. No, finish.
What I'm saying is the infiltration test and the boring, you call the driller, they schedule in a week or so, they stop by, same day, the two are done, probably half a day, the infiltration and the boring. So my point is, you're not gonna be convincing us with just submitting these proposals and invoices that you're doing your part. This is step 0, like we say. This is not even step 1. So we need an explanation.
Mm-hmm. Okay, thank you. Commissioner Shibata?
Thank you, Chair. I agree with the majority of my colleagues. We have had a little more than radio silence from this applicant since 2018. I believe that if they, I don't think it's fair to assume anything other than they're not interested in moving forward, because they haven't been moving forward. And I think that the case before the board should be taken seriously. And it doesn't seem like this is being taken very seriously or with any interest of moving forward. So I am open to hearing what the reasoning for this absence is, and hoping to hear that there is some forward movement. But if board's not satisfied with that, I agree with the position of the chair.
Okay, thank you. Looking at, so we've only ever had one hearing on this, and as we've learned, especially with these types of sites, the owners are often not advised by their counsel anything. You know, they tell the client, we went to the hearing, we need to fill out a few forms or whatever, and that's it. And then as soon as the owners find out by attending a hearing how serious it is, all of a sudden the owners snap to. So at the very least, they come and they say what they can do, what they can't do, or they create a schedule, that kind of thing. But in this case, it's been this 1.5 years and we haven't seen the owner. And I think it's always a mistake by the applicant's counsel not to involve their clients in these hearings. And I really, sometimes I insist that the clients come, and other times, all the other times, I would recommend that clients attend all of these hearings because it's their property and it's costing them money to have counsel attend these hearings, and they don't even know, and the owners don't even know what's going on. So thank you, everyone. Okay, so now we can go to the hearing.
Okay, this concludes the public review session for August 10th, 10 a.m. We will now proceed with the public hearing for August 10th, 2020. So continued hearing items, item number 11, 5106BZ, 18802 Union Turnpike, Queens.
Okay, let's see how this works now. Okay, we see Amanda in already. State your name when you can hear us, please. You're muted, Amanda.
Good morning. Amanda Iannati on behalf of the applicant. I
Morning.
listened to the board's
I
comments.
have to swear you in, sorry.
Oh, yeah,
Yes, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board as you respond on city board member questions?
I do.
Please proceed.
I listened to the board's comments this morning, and I will have the labeling on the elevations switched and resubmitted as soon as possible.
Great, okay. Any other comments on this case? Because we do need to go to the public, and now I'm going to ask Kurt, I guess, we have 14 people who are listed as attendees. I don't know if any of them are calling in to speak on this application.
If you are calling in on application number 5106BZ by telephone, please press *9 to raise your hand, and we can allow you to present your testimony. Again, that's *9 if you would like to speak on 5106BZ.
And 5106BZ is 188-02 Union Turnpike. So give it a second because of course we have time delays, 30 seconds to be exact.
Or if you're attending the Zoom webinar using Zoom, please use the raise hand feature to let us know that you would like to speak on this application. Again, it's 5106BZ.
I don't see any raised hands. I don't see any raised hands or *9s. I'm not sure where the *9s show up.
They show up as raised hands as well.
Oh, I see. All right. So then I would like to, on this application 5106, make a motion to close.
Chair Perlmutter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Shetta,
Aye.
Commissioner Shabeta.
Aye.
Okay, and so we'll try to put it on as quickly as possible. So try to make a submission of the drawing by the end of the week.
Sure.
Thank you.
Okay, thank you.
Thank you.
Next item is number 12, 34312BZ, 570 East 21st Street, Brooklyn.
Okay. We have, well, Mr. Stark, when you can hear us, please state your name.
This is Ben Stark. Am I coming through?
Yes.
Am I visible?
Okay.
Yeah.
A picture of you is visible, not your video.
Start video. Oh, there we go.
There we go.
Okay.
So there are some other people here who are in, are you expected to be joined by anyone?
A number of people, yes. I apologize if our panelist room is not full yet. It's been a challenge for us to figure out the functionality here. So let me just try to send my team here a note reminding them to start their video.
So some people have names and some are just phone numbers. There's one phone number. Oh, that's the talking permitted. So sorry, Kurt, the talking permitted means you've already allowed them?
Yes.
Okay.
And so if anyone is calling in by telephone for calendar number 34312BZ, please press *9 if you are part of the applicant team so that we can allow you to speak.
I see.
And thank you for registering. We are currently going through the list of registrations to allow people to act as panelists right now.
Okay. So I just want to, before people actually get permitted to come in, you must turn off your YouTube video or we'll have to mute you because we cannot hear speaking when your YouTube video is on. That's distinct from your Zoom call. Okay. So nobody else's hand is up. We see, yeah, I see Mr. Harfinet physically hand up. Okay.
And we have
right,
Ms. Rose here and Mr. Tischfeld, and also two of our members here, if they can hear me, Stuart Beckerman and Marian Katsive. If you're using Zoom, I believe if your program is like mine, in the upper left-hand corner, you can click Start Video.
Okay, I saw Stuart's name a little while ago.
There. It's
Or
still
sorry,
there.
the bottom left-hand corner, there should be a button, and if it's not showing up, bring your cursor down to the bottom left-hand corner, and there should be a symbol saying start.
We have Mr. Beckerman and Ms. Katsiv. And then there are two people with phone numbers who I'm going to, so one of them, the last digit is, last digit is 118. Please state your name. First,
good afternoon.
State your name, please.
Good afternoon. My name is Stephanie Hampton, and I'm calling for the opposition. So I will yield my time to the applicant at this time.
Okay, so, okay, thank you. And then we have one more caller who I'm going to unmute, but I've been asking for the YouTube video to be taken off and I keep hearing it every time I unmute. Okay. So a person who has the last three digits of 067, please state your name. 718.
Yes. Okay. Am I unmuted now? My name is Reva Bennett.
Okay. Are you calling? Which case are you calling about?
I'm calling about 34312BZ.
Yes. Okay. So you're calling as a member of the community, right? You're not an applicant. Is that correct?
That's correct. I'm a member of the community.
So I'm going to mute you because we're getting presentation first from the applicant. Okay.
Okay. So just stick around and you'll be back?
Yes, correct.
Okay, fine. Thank you.
Thank you.
Okay, is everyone here ready? Please raise your hands. Please raise your right hand. Okay, do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Yes, I do.
Yes.
Good.
Yes.
Okay. Have them
Okay.
proceed, Madam Chair.
Yeah, Mr. Stark, go ahead. State your name, please.
Thank you. Ben Stark of Hirsch & Singer and Epstein LLP for the applicant, Ocean Avenue Education Support, Inc. As the chair noted, it's been some time since our first hearing in October 2019. So We had thought that we'd perhaps give a brief overview of our application before introducing some of our development team members who can answer some of the specific questions that were raised at the executive session regarding our ongoing efforts to develop 570 East 21st Street in accordance with the board's previous approval. As you know, this is an application for an extension of time to complete construction of the Brooklyn School for Medically Frail Children at 570 East 21st Street in the Ditmas Park neighborhood of Brooklyn. The Brooklyn School is chartered by the New York State Board of Regents as a New York not-for-profit education corporation to operate a day and residential program serving medically frail children that require breathing, ventilation, and respiratory care during all or part of the school day.
Okay, before you go on, where is a copy of what you just said?
So we will get to that, and we have it, and we will be able to provide it to you after the hearing. We will submit a copy of our charter after the hearing has concluded. As you know, in 2015, the Brooklyn School obtained certain approvals under ZR 7221 to develop this 3-story use group 3 school and dormitory facility, having sleeping accommodations for 21 children. And it required certain waivers of bulk regulations of the zoning resolution. As the board alluded to in its executive session, this school will serve the needs of a very underserved group of children at risk of out-of-state placement in a healthcare, non-educational setting, and those who cannot be served in any alternative day school setting in the area. The availability of an educational program as part of a pediatric ventilator-dependent unit within this community will afford children who reside in the area a critical opportunity to receive educational services that lead to greater independence while receiving appropriate comprehensive medical care. With no program of this type in Brooklyn or Staten Island, this facility is needed in the small yet exceptionally challenged community of families having children suffering from chronic debilitating medical conditions will be harmed if it cannot be developed in accordance with the grant. So I had much more that I was going to say, but I think given the amount of questions that were raised at executive session, it'd be much more beneficial for us to move along. I want to introduce the development team that is here today to answer some questions. With me today is Joel Harfinis, the board secretary of the Brooklyn School. Also with me today is both Dean Tischfeld and Hetty Rose of the Alliance Group, a consulting service engaged by the Brooklyn School to help with the educational and program applications associated with the school's preschool and school age programs. And finally, we have Marian Katsive of Bond, Schoenig, and Bond, Schoenig, and King. She is an educational attorney who has been engaged by the Brooklyn School to help with the regional need component of the tuition rate approval. So each of these.
Okay, I have a question. We also have in the room Helen Klein and Shabze Oberlander. Are they part of your team?
Shabze Oberlander is as well. He is a member of our team.
What's his position?
Shabze is affiliated with the Brooklyn School and is also affiliated with Ditmas Park Care Center, the facility that, as our previous submission alluded to, will serve as the interim location while the necessary to establish a per pupil tuition rate that will enable the Brooklyn School to obtain a construction loan to develop the 570 East 21st Street site. So both Joel and Shabze can speak to some of those questions regarding overlap between those two facilities. But I think I really want to start out by making a comment or addressing a comment that's was raised at the October hearing and seems to be being raised again here, which is the Brooklyn School is seeking an extension of time to complete construction of the facility that was approved pursuant to the 2015 grant. This is a school. There's no other way that this could be anything other than a process to develop a school. The BSA approved a set of plans for for a use group 3 school and dormitory facility. And those plans will be associated eventually with a temporary and then permanent certificate of occupancy to operate that facility that the board reviewed back in 2015. We cannot use this process to do anything else other than have somebody develop that site in accordance with zoning. We are here to show the board that for the last 4+ years, the Brooklyn School has continuously made efforts to develop the facility that the board have reviewed in years past. And we do not seek any changes to the design. We do not seek any changes to the program as described so many years ago. It is the same facility. And we can get into some of the more specific questions regarding the financial arrangements of the site. But I think in short, we'd like to say that given the amount of time that it has taken and will continue to take to bring this permanent facility to fruition, the Brooklyn School, which will eventually be lessee of the East 21st Street site from Ocean Ave Education Support, Inc. That has occurred in regards to collateral of the site. It's beyond the scope of the Brooklyn School's purview. That the site will be released from any lien before it is sold to Ocean Ave Education Support. That is for certain. And if we think more broadly about the process as laid out in our March 20th submission, the collateral that the East 21st Street site was used as collateral in part to finance improvements to the Dimas Care Rehab Center across the street that will serve as the interim location for the Brooklyn School. So there is work that has been done to the Dimas Care Rehab Center to accommodate the interim location for this school. And after this hearing is concluded, we will be sharing with the board the temporary certificate of occupancy for a use group 3 school function as evidence that the school is nearly ready to begin operations in that interim facility. So that was one of the questions I was raising. Where is the Brooklyn School in regards to that interim facility? They got their TCO that actually occurred in the midst of the COVID crisis. So a major step in this process has been overcome, and that is now clearing the way for a number of other hurdles to be cleared to allow this institution to begin their operations, which will allow them to obtain their per pupil rate approval, which will then allow them to begin putting a shovel in the ground to build the permanent facility.
Before you go on with that, you said that the mortgage against the subject site will be satisfied before the school starts construction or something like that, right? Is there a representative of the fee owner in this situation here? The one who stands to
the
gain
fee owner of the
subject site
of the East 21st Street site?
Of the subject site,
If the board is interested in some sort of written deliverable regarding the basically the contract to prove that they are a contract vendee of the East 21st.
No, that's not what I said. Listen to the question. You said that the collateral, the cloud on title that prevents a conveyance to ultimately the Brooklyn School as lessee. There's a cloud on title. I want something from the fee owner. I want the fee owner present to say to us what the deal terms are with respect to how long cloud remains on title, so that which impedes the transfer to whatever the name of that group is, the educational support something or other. That's the question.
I understand the question. We do not have a representative of the fee owner here today with us, but we will provide the board with a written statement from that fee owner. We will check to see if they can attend a future hearing. but we will provide the board with written documentation describing whatever contingencies need to be met in order for title to be clear, in order for the subject site to be conveyed to Ocean Ave Education Support.
I'd like to also see whatever supporting documents for that statement.
Say it again?
I'd like to see whatever supporting documents would be related to that statement. I'm sure it's still in writing, the terms.
Yeah, so we will, if we can, like I said, submit both a letter from the underlying fee owner of the subject site. I will check to see if the purchase contract or whatever written agreement between Ocean Ave Education Support and Kalal Bais Yakov is something that could be submitted publicly. I mean, it is a private contract, but we can get you something that will, in our view, satisfy the concerns that there is an agreement with a series of contingencies that are able to be met. I mean, I think that seems like the concern. Like, there are obviously contingencies to get a mortgage release. What are they? Are they absurd and can they not be met, or are they reasonable? And so we will provide you with written documentation showing what those contingencies are.
You know when the owner of the subject property consented to use this property as collateral, whether it's before or after the 2015 application?
If I had enough time in between the executive session and right now, I would have pulled it up, because it was the thing that we submitted. I believe we submitted like the assignments of leases and rents and a series of other documents, and they have a date on them. So it's in our submission. I was frazzled in between the executive session and now. I didn't have time to pull it up. But if you have it open on your screen, it's going to be in the first line of whatever that assignment of leases and rents says. Commissioner Shaidata, do you have that open?
I'm actually looking for it. I did see something like that upon my review.
Okay, continue.
Our team member, Joel Harfiness, I think can answer that question.
Okay, so I checked it between the executive session and now, and it took place in July of 2017, which was after the approval. And if I remember correctly, at that point, we decided on opening our interim location at the Ditmas Park Care Center site. And this was part of the process of allowing them to build so we can start the program over there.
I think that's a really key point that we want to say again, which is it wasn't that the East 21st Street site was used as collateral for some willy-nilly real estate venture. It was being used as collateral for major improvements to the Ditmas Park Care Center in order to accommodate the interim location. It's part of the continuous efforts to develop East 21st Street was to do major alteration type 1 work to the Ditmas Park Care Center.
I'm going to have to stop you right there, Mr. Stark. Mr. Harfiness, who obviously knows more about this subject than you do, has his hand up. And please remember, Mr. Stark, you're a fact witness. If you don't know the facts, let someone who knows the facts state them. Okay, Mr. Harfiness?
Yeah, I would like to add that the collateral is for construction loan for the Ditmas Park Care Center. The initial collateral was for the period of the construction, which was to be for 24 months. It was extended because construction took longer, but I think it was extended till the end of 2020, which was the end of another couple of months. It might be a couple of months longer, but I can check on that and we can submit that. But it's basically a pretty short time frame for the collateral, just to finish, for the Ditmas Park Care Center to finish their construction, which is almost finished.
I have a question for you about that collateral. So how much does that collateral represent relative to the total construction loan?
So it doesn't have I don't think it has a figure, because most of the construction was from the Ditmas Park business, the financials. But because there was some sort of, they were going to use this property for staging for the construction, and there was some rental, some rent that the owner of the property is going to collect from the Ditmas Park Center for the staging space. So the bank wanted to have that rental income assigned to the collateral for the loan, but it wasn't a big part of the collateral.
Can you get us more information on the relative value of the collateral against the total loan for the project?
I hope you can get something like that, because it isn't broken down, but I can definitely try. I'm not from the Ditmas Park Center, so I'm from the Brooklyn School.
Oh, I'm sorry. So there is somebody from the Ditmas Park in your group, right?
Mr. Overlander.
Mr. Overlander. Mr. Overlander, hi. Do you have this information? I don't see where it is. Mr. Overlander, can you hear us?
He might be muted and he doesn't know it.
Yeah, Mr. Overlander, please unmute yourself. I'm asking him to unmute, but there we go. Please state your name. Mr. Overlander. Still can't hear him. Okay, so in the meantime, while we wait for Mr. Overlander to be able to figure out how to link into us, can you please have him find out what the amount of the collateral is relative to the total construction loan? Okay, continue, Mr. Beckerman.
Mrs. Stark, you mean?
I'm sorry. What did I say? Sorry, Mr. Stark.
Okay, I wrote down tried to write down all of the questions raised by the board. So I am going to try to see what maybe the next high level issue is to approach. But maybe I'll just give a more high level statement, and the questions kind of will flow from there. We believe that our March 20th submission laid out what the process is to develop a facility like this, and the challenges that the applicant team or the Brooklyn School themselves have faced in getting all of the approvals necessary to get tuition rate approval, to get a construction loan, to put a shovel in the ground. But I think what we want to say in this regard is that because the Brooklyn School, as the chair mentioned, is a new organization without a history of operating, and did not have an existing facility. They found, after the board had granted the variance in 2015, that although there are a series of approval processes that must be completed in order to get that rate approval, they can't operate, is the key point, they can't always operate at the same time. There is a degree of linearity here. Like they determined that they would need to construct an education program for both the preschool and school age programs for the school. That process itself required a lot of back and forth with the state of New York, and only after that program had reached a certain ripeness in its development could they begin to proceed with other components necessary to invariably get rate approval. So I think what we want to try to help the board understand is that between 2015 and 2017, what was being worked on was devising the education programs, and that yes, they ran into trouble with the consultant they were using at that time, completing that process. And in a way, once new consultants were engaged in 2017 or so, there was some amount of duplicative work in re-engaging the state of New York on those on the building of those education programs. If we were a more corporate school operator operating regionally or nationally, there may have been right out of the gate in 2015 the ability to hit the ground running on things like that and not have a setback like they had. There was a setback, but we believe under the law that this still is evidence of continuous pursuit. I know that it's a question of the board, but why weren't some of those programs being developed during the BSA process itself? And the answer is pretty simple, which is that without assurance that the BSA approval will be had, the expenditure of tens of thousands of dollars on consultants to begin building those programs, which are we're all being funded by donations from parents. That's lending to this idea that it had to operate linearly. They did not have the resources to attack things on a multi-track front. And so once the setback after around 2015, 2016 or so occurred, they were in a way re-beginning the process to begin to develop the education programs. Those had to reach a certain degree of ripeness to begin the actual rate approval applications. And that rate approval application itself had to, in a way, wait until the regional need application process itself, which is regional need for an educational program of this type. I don't want the opposition to be confused with need associated with healthcare facilities. There's regional need for this type of educational program. And so I hope the board is starting to understand that there are certain processes here that had to be on pause while other things caught up. And then as other things caught up, other things had to go on pause. But despite the setbacks in 2016 and 2017, the consultant team that the applicant has with itself now has made tremendous strides towards establishing the interim facility across the street at East 21st Street. Like I said, the temporary certificate of occupancy has been obtained. The applicant is very close to obtaining the regional need and educational program approvals necessary to have their tuition rate. They are confident that the interim facility will be open in the context of this whole process relatively shortly, and that will enable them to begin the process at East 21st Street.
So for lack of a better, let's say, put it this way, is there anyone in your team who's able to speak with firsthand information about this? So I talked about this lost puppy syndrome. Is there someone in this group of consultants who is actually leading this and can actually tell us what's going on at this very moment right now, and what the steps are to setting up this interim facility, and how long the interim facility has to operate before New York State Education Department will even consider the use of a new site and fundraising for the new site, et cetera, because that's what the board is talking about, a very premature application. And how do we convince ourselves that this can't go on for 20 years, right? You can't be like the Strive Right School where they operated for 10 years before they even decided to have their own facility, et cetera. Is there someone in this team who is able to?
Absolutely. I think this is a good moment to introduce you to Marianne Ecb, our education law attorney working to obtain the regional need approval for the interim facility, and then eventually later on the permanent facility. But Marianne, would you like to introduce yourself? You're on mute. You're on mute, Marion.
How's that?
There you go.
Okay,
State
good.
your name.
Good morning. I'm Marion Katziv. I'm a member of the firm of Bond, Schoenig and King, and I'm an education lawyer. I'm a school lawyer. I represent schools that are getting charters, that are starting up, and that are seeking approval from the state education department to offer services to children with special education needs. And I've been doing this for a long time. The Brooklyn School for Medically Frail Children came to me in 2017. And since that time, we've been working continuously, I would say, to find out what the need is and to develop relationships with the New York City Department of Education and the New York State Education Department. This is a facility that is needed by very many people. I've had moving conversations with parents and of course with doctors, because children can't be discharged from hospitals unless there is an appropriate program for them to join. Parents are heartbroken to have to send ill children to different states and upstate and far away. And even sending a child to Queens who you want to be with every day is a heartbreaking thing. So those are facts that I've become immersed in as we've gone through this process. But the short answer with respect to what are we doing is that on June 16th, we did submit the application for identification of regional need to this New York City Department of Education and the State Education Department. The need application is not only to find out whether there's a need for the program, that's pretty clear, but to find out where the greatest need is, because with 3 or 4 classrooms, you can have children who are preschool, you can have children who are 10, you can have a child who's had a sudden accident at age 14 and needs this kind of facility. So we needed to determine where the need is in order to create a program that could then be approved by the State Education Department, whether we have preschoolers, whether we have first graders, whether we have 8th graders. This is not known. It's not possible to look at an existing wait list that has been developed over many years, because parents who have children who have needs of this sort don't wait for a school to open. They must attend to the medical needs of their child first. And so if that means sending them to a facility out of state or upstate, they do that. The need can only be assessed when you're ready to go, when you're ready to accept children. And that did not take place until a certificate of occupancy was issued. And shortly after that, we did submit to the New York City Department of Education and the State Education Department an application to ask them to look to see who is on existing waiting lists right now and what sources they would need to identify the current need. So that is where we are right now. And right now we've had a preliminary meeting after submitting this application on July 21st. And we've promised the State Education Department to get back with some more detailed granular information by August 21st. I hope we can do that. The COVID quarantine has, of course, significantly interfered with the ability of parents to seek out appropriate settings for their children. Children were not being moved into institutional settings during this period. Schools were closed. Committees on special education were not seeing children individually. So we now have the New York City Department of Education committed to looking closely at their home instruction lists to see how many children there are who are not receiving more than an hour a day of education because of their inability to be in a regular school setting. And that's where we are right now. So hopefully we're moving forward. That's just about it. And finding out where the greatest need is, not only whether there is a need, but whether we should be focusing the few classrooms we have on preschool children or early elementary children, or whether there is even a need for placements for middle school children. We just don't know at this moment, but we're in process of finding out.
So assuming that there's a determination that there's a need at all and a need for 5 classrooms, how long before there's potentially approval to begin functioning as a school?
Well, the school could, as you understand it, the school is chartered. It could function as a school, but these children are entitled to a free appropriate public education because they have severe disabilities and cannot go to regular public school. In order to provide a free appropriate public education, the state has to determine what the correct tuition rate is. Once there's a finding of need, which we hope is going to take place shortly, as I said, the COVID epidemic has certainly interfered with the ability to identify who is in need of placement for school right now. Once there's a finding, the state gives the applicants only 45 days to submit the full application. So there is a cutoff. There's not, and the reason, of course, that there's only 45 days to complete the application is because needs change. If we can find out within the next 3 or 4 weeks that the real need here is for preschoolers or for first and second graders or middle school children, then the team that is doing the need application, that's not me, I mean the content application, will have 45 days to submit a full application.
Okay, so the school could already be functioning, is it?
It could be functioning, but children can't be moved into a school at this point because school has been closed for everybody. And especially children with very vulnerable immune systems are not being taken from their homes or taken from hospital settings.
Okay. Okay, and the person who is working on the program, who's that person on the school program?
That would be our two representatives of the Alliance Group, both Dean Tischfeld and Hetty Rose, who are with us today.
Okay, can one of them please speak on the status of your educational program?
I could speak. I'm Hetty Rose. The application is, the majority of the application is complete. Of both applications. There's a preschool application and a school age application. We are just waiting for final feedback from DOE regarding the need so that the budget itself and whatever last minute programmatic relevancies can be put into the application based on what that need will ultimately be.
So the need is what Ms. Katsev is talking about? Is that
yes.
the same need? So you need to wait for the determination from education department. I thought that's about need, not about the tuition.
It's a formal requirement. You have to obtain the need approval first.
Okay.
And then within that 45-day period, you submit the preschool and school age applications. You can't submit those applications until and unless you obtain the need approval.
Okay.
And Madam Chair, just a note that as Marion said, the receipt of a CO was a prerequisite to her need application. So it's like CO need program. And so the CO process took years to do the work to actually build out the Ditmas Care Center for the facility.
Right, but when the applicant came to us, it wasn't aware or something about any of this stuff. It thought it could build a school without a school.
I mean, in all fairness, you do have to have, I know you mentioned earlier in your executive session about how the charter school works in terms of just starting the program. But with this particular type of school, a non-public school, you do have to attach daycare approval, your C of O, building inspection reports, and a floor plan that has to be very detailed, detailing what each room will be used for and the square footage of each room, as well as a very lengthy fire and disaster plan. And without having the actual building built, we would not be able to include those items. And if we don't include the items, then state ed won't even entertain reviewing our applications.
This is confusing because we look at so many school applications.
Backwards.
Not for special needs. Well, yes, also for special needs schools. And those are schools not yet built or schools where they haven't moved in and they're looking for an approval from us, and they give us formal documents to show that they have been recognized as a school for so many kids with a curriculum of X.
It
Is
could
that
be a
because-
private school. It may not.
No. We look at charter schools and private schools.
But the charters, this is a non-public school, which we get the tuition rate directly from New York State Education Department. There could be, it's the charter schools and out the non-public schools like us. It's complete. It's different. They're different regulations and.
No. We get both. We get charter, non-public, if you want to call them private schools, schools for special needs. We've had quite a number of special needs schools, so they're also getting some kind of tuition reimbursement. Normally, we don't have a conversation about their tuition reimbursement. It's not, doesn't come up. But we do have proof that they're a school and that they have a curriculum and that the curriculum is supporting the size of the building and the layout of the building and so on. I'm a little confused by why we're seeing this so differently from the other schools. Some of the charter schools we have are brand new charter schools. They've never functioned as a charter school before, but we're presented with an approval from state education and city that they're allowed to operate with this many kids for this grade levels and so on.
Not for the non-public schools. It's not. We could even attach an application for you to see formally how the process works. It's not how it's done. So it may have been a different scenario, but for the non-public schools that we are seeking approval for with respect to these applications, you would never have the state ed approval without the formal application going in, which includes everything you said, the curriculum and the breakdown of the classrooms and staffing ratios and supporting licenses and all the policies and procedures, which is huge related to the program. But without that, you can't just come in with state ed. You're not going to just get, at least with I can only speak to our industry, you're not going to have state ed approval already.
I think the confusion is simply that the kind of program approval that you're talking about is the objective of the application. The application, the need sets the stage for what kinds of services are needed. Do we need more preschool children? Do we need more seats for middle school children? Once we have that need identified, Hetty's group will do the application, and then the ultimate result of that application is exactly what you're talking about, a formal approval. You're approved for 3 classrooms, 4 classrooms. The ratio is 6 children to 1 teacher to 2 assistants. You'll get a very detailed approval, but that's a step away. And yes, we're not at the position right now of the approved non-public schools that you see. That is where we're going.
I'm a little confused. Okay, so all this conversation though is about those 5 rooms in the Ditmas Park Rehab Center. What's this have to do with the variance on the site across the street?
So as we laid out in our papers, and we will lay out in a follow-up submission as necessary. Given the exceptionally unique nature of the program, the lending community cannot extrapolate the revenue for the projected revenue for the East 21st Street facility until they see the per pupil tuition rate reimbursement.
Stop. No, stop. All we're talking about is applicant. I see Commissioner Shonda's hand up. So all we're talking about is right now proving to various education departments, state and city, that you're entitled, that there's a need for this kind of a school, that the need is for children of ages X to X, X to Z, and that eventually there will be some kind of tuition reimbursement set for those kids in that school in the rehab center. That's all that's going on right now. How does any of this, and Mr. Stark, I don't think you know the answer, so please don't try to answer it unless you really know the answer. How does any of this relate to the new building to be constructed on the vacant lot that is now has a cloud on title, which I'm reading about right now? How does any of that relate? You're going to eventually get approved for this school with, we don't know what the mix of students is. And eventually you will open this school when both the state allows you to open from the technical perspective and the governor allows you to open from a COVID perspective. At some point, the school will operate in the Ditmas Rehab Center. How long will it operate there before there's even a flicker of ability to obtain funding to develop on the vacant lot across the street?
I can answer that. I've been involved with this applicant team for over a year now. And I would say that you already answered the first half of the question, that once this initial process is done, then it opens the door to begin the second part of the process in much more earnest. Now, as Marion is working towards the regional need approval for the interim facility, a similar process would play out after the interim facility opens to establish the regional need for a wider student population. Now, that might seem daunting to members of the board, but from our perspective, our team's perspective, being involved in this process since 2012 and having our thumb on what the need is in Brooklyn, Staten Island, and other areas, we believe our team believes very strongly that they will show that need. Marion can speak to conversations that you're shaking your head, but it's true.
No. So I'm looking at it as a developer. Where is the person who represents the developer on this team? It's a building to be built. Someone has to know how the funding will be raised, what the process is. So I'm thinking one of the consultants here knows what the process is. After you've got a school operating, does it operate for 5 years? Does it operate for 10 years like the Strive Right School? At what point has the school proved its salts sufficient to obtain?
The two steps are get the per pupil tuition rate and then get the regional need for the wider student population. It's not, that's it. And so we're very close to accomplishing the first step, which is the per pupil tuition rate generally. And then after the interim facility gets up and running, someone like Marianne herself will begin immediately to begin asking the state of New York to confirm that there is a regional need for a wider student population. Those two deliverables, per pupil, each individual student, and a demonstration of a need for 40 students or so are the two deliverables that can be taken to the private lending community to get a construction loan.
Commissioner Shanda, you had your hand up, and then Commissioner Sheta.
Yeah, as I'm listening to this, I do have to commend the team for putting together the March document. Though, as I'm hearing the applicant's team discuss it, I think that letter can be broken down in a more intricate detail of step by step. We understand, well, I understand the need for a two-step process, as you call it, the catch-22 process. I understand the need for the two-step. So since you have to go through the two-step process, break it down by each deliverable items. And so you have one deliverable, which is the temporary site. And in parallel from what you are doing is to get to the final destination, which is the subject site, if I understand correctly. So lay out exact time frame from each one of those tasks, temporary and permanent, and indicate where you are in that timeline and how long does it take. Some of them are known, like how long does it take for you to turn the application around? As Ms. Katz mentioned, Katsive, mentioned that it takes 45 days to submit the application once you have the regional need identified. There are some fixed dates. Then there are those that are unknown. Once you're in the temporary space, on an average, and maybe Mr. Tishfel can answer to that because he's from the TAG team, to respond as to, on an average, how long does it take for an application to go from an operation to move from a temporary site to a permanent site? So please provide a very detailed, like I'm looking at a spreadsheet where you provide each step that you need to deliver and the deliverable timeline. And that goes to what I was suggesting is doing a more of a expectation of deliverables that we can all understand. And also a narrative with it that explains why you need to do this. Because this is a unique school, this is a unique program, it is, and what are the approval process. Am I making it clearer? And I would like Mr. Tishfeld, if possible, to explain along with Ms. Rose and Ms. Katsivi, how this whole thing would work out.
I could.
In writing, and you mean explain it in writing or now?
If they can explain it now in a simple way, and then definitely in writing.
Okay. Oh, go ahead, Mr. Tishfeld.
Okay. I've been involved in these programs for about 25 years. The population that Brooklyn School is dealing with is medically fragile, which is a little bit more complex than the typical population that you've mentioned in, let's say, Strive Right. There's very few operations that are out there right now. And when they had to start out as well, it took them quite some time to gather students together and then reach up to a point where the tuition rate and the number of children that they were providing services reached an optimal level. As far as where Brooklyn School is right now, since they're looking for a need and they haven't established the full need yet, and we're about to get on have a meeting with the New York State Education Department in the next couple of weeks, hopefully they're going to come back and tell us there's enough kids to start the program. Once they say there's enough kids to start the program, the application will be submitted. It goes through a very detailed process. Rate setting has to look at it, and also the division of budget. Typically, budgets that are given to regular programs are what's called the regional weighted average. But because the medically fragile operation is more unique, those programs' tuition rates are much greater than a typical program that services kids with delayed needs or even on the spectrum, for that matter. That process takes quite some time before a tuition rate comes back. It could take a year before they finally come back with a rate. It could take 6 months. The division of budget sets the tone for that. Typically, that's been my understanding of the program. As far as getting the program started, which is at the temporary site, and I think is an excellent idea, while the other site is waiting delivery, to get ready for an even larger population. Let's say, for example, we start out with 16 children and the site is set to operate at 24 to 30 kids with school age and preschool application. I'm sorry, is someone speaking or, okay. School age application. Once we finish the year and we know how many children are in the program to get it started, that would set the tone to know when the other site can be ready as well. If you're asking me to project when do I believe, and I can't attest to exactly how the needs of the children start to come into the through the system and they get into the program, it could take anywhere between 1 to 3 years at that point. It depends how fast the need comes in. It's very hard to attest that, but to get the program started, which is at the temporary location and has the ability to operate and open up 5 classrooms, and it's very close with all of the approvals that they have in the building and everything, is a tremendous start. I can tell you that there are programs out there that service these types of populations, and we can certainly provide you with supporting documentation that shows the tuition rates for these operations and the process that it has to go through to get the program approved. Obviously, everybody's been aware of the COVID crisis that's been going on since March. Evaluations and the intake process for even organizations such as Strive Right have completely stopped over the past few months because they've only been able to do teletherapy services. These teletherapy services has caused delays in the intake process and will also cause delays in the need process. The system has to work together. So as far as Brooklyn School, which is a new organization that has to come in, the New York State Education Department, located in Brooklyn, Brooklyn offices, is working with the state up in Albany to gather together and put together all of the data of all of the children in New York State, which could consist of children that are even attending programs right now that might find a better placement in the Brooklyn School operation, because it's really more tailored toward the medically fragile population. The regular schools that you typically see is more or less a shell with classrooms. They do not have the sophisticated medical equipment that the medically fragile operations have in it. And I've seen what the build out that has gone on at the current location, the temporary location that's about to be built, and it's quite sophisticated. And it's in line with several other medically fragile operations. So you can't really compare. You have to wait for the children to come into the organization because you have to make sure the program becomes financially viable, which it will. And that's why you've seen organizations such as Strive Right, and New York State has 400 other providers that have had to go through the same exact system when they were starting out, where they find a temporary location and then expand to a certain population where they can become more financially viable as it goes along. It is sophisticated. It is not the same as a private school or a charter school. They came out with a new application roughly 5 years ago, where is now even more complex because they don't want anyone who is interested in serving special needs population coming into our industry, which is why there's been quite a few more program compliance audits and approvals to pass the Special Education Quality Assurance Department. These departments are very sophisticated, they're very unique, and they go through from our area in Brooklyn all the way through to Albany. They have multiple levels of departments. The DOB has to approve it. The Division of Budget is final. And the Division of Budget is waiting right now, as you know, because there's quite a big, they're waiting for the programs to continue because Governor Cuomo is waiting to handle all of the budgets for all of the programs that are coming in right now. And these delays are very difficult. If they can't themselves let everyone know how they're going to get the new programs, the existing programs started, you can't really put an exact timeline on when the medically fragile operation will become, because it's even more complex. We visited multiple schools of medically fragiles, all the way from local into Yonkers, all the way up into Albany. And we know there's very few that exist around the immediate area, which Marion explained, that there's quite a few children that are just either in hospitals or in settings where they're not receiving the quality of services that they could be. An hour a day is not enough. 5.5 hours a day is a typical school setting. These children are in need of the service. We have 2 applications, 2, not just 1, 2. So we're serving ages from 3 to 21, and we're going to be looking and seeing how this program is going to place these children into the different classes because of the age gaps of a lot of different kids, and how the parents are gonna be approved through the natural process of the New York State Education Department. The rate setting system does follow like that. I've gone through the system. I'm 3rd generation. My grandfather started in this industry in the 1960s, my father in the 70s, and I started in the 90s. So I'm aware of the rate setting process. It's been around since the 1980s, and I've been working with rate setting unit and all of the heads of the department who I worked with over the years, and the accountants have now become the directors of the department, and the system has not changed. We need to get an appropriate rate. We'll get a starting rate, and that rate will be a help to Joel in helping him go over to other banks and letting them know that they're an approved school with a program approval letter, and that they're going to have a rate posted on the New York State Education Department website, like several of the other providers that you've been, mentioning before. You have to start from the beginning and then nurture your way through it. It could happen very quickly. it may, but I'm trying to be safe in giving you a figure since we're in the month of August and we're going through a COVID crisis, and they're also going through an approval process. I have to say that I really believe the process, to move could take anywhere from 1 to 3 years because you have to establish yourself first. But there's a heavy need out there. I've seen a lot of programs that are even over enrolled.
Sorry. What would take from 1 to 3? What would take from 1 to 3 years? Getting the rate set or getting what?
Oh, 1 to 3 years from getting them to move the program from where they are now. The rate being set could take anywhere from 6 months to a year generally from what I've seen. But we are in a COVID crisis.
What do you mean from moving the program from where they are now?
Well, they're going to start temporarily at the current location, right? And then the goal is to get them across the, across the way, because you've been discussing the other location. So in order to do that, you have to start at one location before you move in another, and you need those approvals. Pardon me if you want to speak. I see that you're getting.
No. So you say from 1 to 3 years. Pardon my skepticism. The idea that you're operating for a year and they let you say, we're going to fund a $35 million project across the street after a year of being in operation. So what's the realistic view of the school operating once it gets those approvals in this building that it now has a TCO for, and at some point there's a proven need for more kids needing this, and this school has demonstrated that it can handle it, which is a whole other subject. We have seen failed charters. And then the reality of funding for this large expensive building. Let's do reality. It's not a year.
Well, like I said, 1 to 3 years, I believe, is fair to say. 1 year is tough, but it seems like everybody wants an immediate right now, and the immediate to me is really more or less a rate and getting the program started to fill at least a good portion of the classrooms, anywhere from 2 to 3 classrooms. And I think as the program gets even more known to all of the hospitals that they've contacted and the parents that have children that may be getting service upstate, I believe the process will move quick. But from my experience, I usually see programs take anywhere generally between 1 to 3 years, depending upon the population. It is a medically fragile population. I believe the state is going to make a move rather quickly, because again, if you take a look at what they've accomplished at the current location, the equipment and the whole setup is completely different than opening up a program that's servicing children with speech delays, again, or even autism. I've seen programs that service both start out with a small amount of kids, anywhere between 16 or 20 or 34 kids, and then over a 3-year period, they've grown to close to 100. If you want to speak, Ben, because I see you saying something. Okay.
I'd like to recognize Commissioner Sheta, who's had his hand up for a long time. You're muted, Commissioner Sheta.
Yeah, thank you, Chair. I want to thank Mr. Titchfield for his response, but it appears to me that the 1 to 3 years period is not on the critical path of moving from the current location to the other location. In order for them to move to the other location, I believe they have to secure some financing, some fundraising. And when asked about this by the chair, the response from the applicant actually for me wasn't that helpful, because he said, I cannot answer this. And I'm like wondering, if he cannot answer this and we're not sure about securing the money to initiate the move from the current location to the permanent location, I'm not sure if the true reason for holding this project to move forward is just the tuition rate that need to be determined by the state. Is it the money in addition to the tuition rate? And I'm actually surprised by that kind of response, because if they applied initially for a project like this, and now after the expiration of the time to construct, and they are applying for an extension and they are saying that, I'm not sure how this is helpful to them.
Commissioner
Right.
Shea.
I'd like Mr. Harfiness to answer that question, please. And also,
Yes.
is Mr. Oberlander his name is on the collateral agreement. So it seems in fact, he's the signator on the collateral agreement. So it seems like he's the one to answer a lot of these development questions, but go ahead, Mr. Harfiness.
Yeah, so first of all, Mr. Oberlander told me before that he had some technical, he was talking but it didn't come through. So he communicated some things to me, but maybe he could do something in writing. As far as the question that the chair, first of all, it's not a $35 million project. The $35 million project was the much larger project across the street this covers part of that collateral. It's a $10 to $15 million project probably. Second of all, I think the team could correct me if I'm wrong. The state is not gonna pay $50 million outright for the project. All they're gonna do is they're gonna approve a rate for each child. And once we have a rate for each child, then we have projections. We have a revenue source. We can go to the bank and take it and explain our business model, how we're gonna fund it. Now, about the need, we think, and our plan is that once we're in operation, because we have been in conversation with a lot of these people in need, once we're in operation, once we're really there, the interest would be very easy to figure pretty quickly when we want to go larger and when we're ready to build out. So we think that it's going to be a year or two after we're in operation in the school that we'll be able to really know, to really plan going forward. So we're going to have a real understanding of the need.
Chair Promoter, I just want to get back to.
Sorry, I don't want you to interrupt. Please raise your hand if you want to speak and I'll recognize you. Please finish what you have to say, Mr. Harfiness.
So that's the plan for going forward, which is I don't know exactly, the process is not my expertise, but the plan is that the need is going to be the hardest part is now because we're not existing and every day that nobody is signing up for something that is going to be there in a half a year or a year from now. Once we're in operation, we would be able to really have a much better feel of what we need to do going forward.
Are you working with a development consultant? You know, a construction development consultant for the school building?
So if we're working with a consultant meaning as far as the cost of the operation?
No. So maybe you heard in my in the review session, I talked about the lost puppy syndrome, where not-for-profits who really don't know how to develop a project try to do it on their own and then they realize they can't. You learn that by hiring all of these specialists subsequently, right? Do you have a development consultant that you're working with who would help you put together the plan for how you might develop this building once you got the rate determined, the tuition?
Is that about, because there were, are you talking about architectural? Because there was a plan submitted with the initial
application. That's called architecture. There you go. You guys need to hire a development consultant.
Sorry, Chair, I have to interrupt you. We have a development consultant, Joel. It's Zev.
Where are they?
We have been in touch with contractors and we have been, but we're not ready to do it.
One of the members of the board of directors of the Brooklyn School is one of the most experienced development consultants in the borough of Brooklyn. That's again pointing to the nature. It's Zev Steinmetz of Complete Construction Development. We've done.
He's on the board.
Our office has done countless projects with Zev. They're involved in massive projects in downtown Brooklyn.
So they need to be part of this discussion because we're talking about the development of a building and nobody seems to be able to figure out the answers to when it's going to actually happen, which is
I don't believe that that's fair, Chair Promoter. We're talking about a prerequisite to getting a construction loan.
Okay, I don't want to argue with you. I am asking for the next time that you come to this board that you bring with you this expert on development so we can ask questions about how the project is going to move forward in the face of all of these other issues. And I see Mr. Tischfeld's hands up, so please.
Hi, I just want to answer Commissioner Shada and also help you feel a little bit more comfortable. I'm comfortable with the fact as a consultant and being involved in these projects, knowing what they've accomplished so far. And I know you brought up, I'm not sure if it was Commissioner Shada or yourself, Chair Perlmutter, about using fundraising and different techniques to fund it. But I believe because of the building we're looking at today that they're using as a temporary site, which I've seen, you know, and how far they've come, it is a very, very good indicator that they have created a site for these special needs population. And by doing so, I think that that would help them or support them and make you feel more confident of where they're going to go with the next operation. If they hadn't have done that, I could understand you feeling that way, and we would still be talking about the process. But I have to say, the process has moved considerably well based on how long I've been in the field and where it's going because of the population we're dealing with. I will want to add, to give some comfort in terms of the need, that I work with another school that provided preschool medically frail for quite some time, not school, but preschool. And they've always been able to fill their program up. And this population, which we're intending on doing both school and preschool, because we'd like to have the flow of the population work well, especially in the beginning and then further on when we move, you know, across the way and develop the program into, you know, a fantastic program. I really truly believe that everything will come into play, but exactly giving you, let's say, the so-called, for lack of a different word, the crystal ball as to exactly when that will happen. I can only tell you that from my experience for this period of time, I've seen it happen, you know, and the schools are posted on the website. I do not see those schools taking 10 years like when we brought up Strive Right. I can't speak to Strive Right. They're not a client of mine. I can't speak to their process, but I do know they're an approved school. But I can't speak to, you know, whether or not they service that population, which I don't believe they do, because it's quite unique and complex. And I think, as you know from listening to us and describing the type of population, and if you actually, and I can't say you have or have not, but what I've actually seen, and I've been in these classrooms touring either an existing clientele and an operator who I've worked with for about 25 years, who's no longer in the field right now, and looking at the operations that are in Yonkers and Albany and that, I found that these operations are extremely sophisticated and take some time. But I'm confident that the New York State Education Department, who has worked very continuously on this project, and like Marion mentioned, again, I have to bring that up, they're scheduling another meeting in August. The meetings are going to continue, and then they're going to find more kids. And then as the program gets into its ups, you know, gets started, as far, and also they're going to be a strong advocate for it, because they are now. You know, there's been tremendous amounts of meetings on it over the past several months, because they know how close the project is to getting underway, and they themselves are very excited, you know, over this program. I'd love to see this program, as I'm sure you would, get started.
Okay, good. Thank you. We need to move on because we have a lot other hearings, but what I want to ask is, do commissioners have any questions before I just want to address the issue of the badly maintained site. Whoever is maintaining the site, Mr. Harfiness, can you talk about that? You have violations about the site?
I believe that so at the previous hearing, or I don't remember exactly, there were, it was brought up, there were 7 shipping containers and it was badly maintained. We had the landowner take care of all of that, and it's completely empty now. I'm not exactly sure about
Joel,
the specific. So
Yeah, okay, the reason that I'm asking, and I see Mr. Stark, just one second, there is one violation on the site that is from September 2019, and it says the house demoed under section, application number, whatever, signed off at time of inspection, property being occupied as parking lot with approximately 10 vehicles, also 2 shipping containers and 1 industrial machine. Those have been removed, is that correct?
So we removed 7 shipping containers. I don't know what those 2 containers is. It might be on the other property. I can check on that. I know that the parking has been stopped. They're not using it for parking.
Okay.
So it has been, somebody mentioned medical waste. I've been there and there was no medical waste there. Might have been there for
trash, whether it's medical waste or not. There was a lot of trash there. We have photographs provided by community members.
We cleaned up the trash and that, and we submitted a couple of corrections of the violations. Yeah. I'm wondering if there's still one open, then we need to have a look at it. I'm sorry, I didn't know about it.
We've got a number of violations
and we removed
submitted to the board certificates of correction. But if there are other ones, we will look into it and we will.
So I can check on the rest. I'm sorry for that, but as far as I know, everything was taken care of. But I guess it wasn't.
The two collateral agreements, one of them says that the site itself, the subject site, is being rented for construction.
Staging, correct.
Right, staging. So I'm not even sure if that's allowed under zoning to be using it for construction, but maybe it is.
I guess we'll have, okay. So yeah, staging is usually when they get deliveries for the day.
Yes. But you're not staging on site, you're staging at someone else's site in a residence district. I don't know if that's the reason for the violation. They're saying you're parking these vehicles, which sound kind of like they're staging vehicles, but I don't know. All right.
Yes.
So, yeah, Mr. Stark, please make it fast. We have a lot of people who want to give testimony.
Absolutely. I'll be very quick. I just want to say that, just to recap a little bit, you had asked the question at the heart of this whole process, which is, it sounds like this applicant team is quite close to opening up an interim facility. They're very close to establishing the regional need for that interim facility, getting the tuition rate approval for that interim facility. But what does that mean in the long run for the permanent facility? As Mr. Tischfeld had said, he believes that we will be able to establish that need within 1 to 3 years and pair that second need process with our per pupil tuition rate to receive a construction loan, to put a shovel in the ground for the permanent facility. And so the question back to us was, well, how are we sure that that can happen in 1 to 3 years? I mean, Dean can speak to his experience, but how do we really know when the applicant themselves had submitted a letter from Strive Right noting that they had spent 10 years looking for a temporary facility? And I want to point back to something that Marion had said earlier, which is that, again, this is not a school for auditory issues or a more common special education facility. It is highly unique. We understand the need based on the 7 years that we've been working on this process. And as Marion had noted, we are quite confident that this hidden need is going to emerge quite rapidly once this very real facility is, the interim facility, is operating. And that's because these parents, the parents who have
okay, Mr. Stark, we've heard all of this part. We know this part. Please, we have a whole bunch of people who want to give testimony. So unless you're going to add something new to the conversation, I need to move to the public.
The last thing I'll say is that we believe that in 1 to 3 years we will have that construction loan. We will break ground.
Something new to the conversation. I'm moving on now, and I'm muting you. I'm sorry, you can't keep going on. Okay, so now, Mr. Steinhaus, what we're doing is, you need to help me with this. What we're doing now is we're inviting the public to speak on this application, which is application number
34312BZ, which relates to 570 East 21st Street, Brooklyn. If you're a member of the public who has called in using your telephone, please press *9 to raise your hand so that we can recognize you. Again, if you would like to speak on 34312BZ, which relates to 570 East 21st Street, Brooklyn, please press *9 if you called in on the telephone, or if you're using Zoom, please use the raise hand feature. We have 4 people so far who have raised their hands, and we will get through our list now. Ms. Hampton, you are now unmuted. Please state your name and you have 3 minutes.
Yes, good afternoon. My name is Stephanie Hampton, and I oppose the time extension for variance for 34312BZ at 57 East 21st Street in Brooklyn, New York. Now, the reason why I oppose this extension is for several reasons. We have been going through this, the community has been going through this for several years now, and the applicant has failed to provide any proof that this is truly a school through the Board of Education. There is no charter, there's no additional mandatory documentation for operation of the school. And further, based on their SME, the subject matter expert, Ms. Marian Cabot, she said that she has been working on this project since 2017. They just submitted in June 16th the application and needs for the Department of Education. It takes 3 years to submit an application of need. That's ridiculous. There is poor project management principles being applied to this project. They're not using Lean Six Sigma or any known project management applications to ensure that there's timely execution of this. This has been dragging on, like I said, 4 years. In addition, they have been dumping garbage, medical waste in that lot. This is proof positive by the documentation that we have submitted relating to this claim. There is photographs with biohazard markings that further validate this. In addition to that, we had trained, licensed medical professionals also observe firsthand that this waste was medical waste. Now, if they can't manage the property when there's no medical facility on hand, what is to say when a medical facility is on hand, how are they going to handle it? They have zero confidence from this community that they are apt and ready to handle the responsibility of having a medical facility, because it's not a school, a medical facility on this premises. And then lastly, I would like to say that Commissioner Sheta said that they haven't provided any substantial documentation showing that they have the financial wherewithal to get the funding for the establishment of the school. And, this is just evident that these are just lost puppies trying to get an extension for a project that has no end in sight on when they can fully accomplish it. And I yield my rest of my time. Thank you.
Thank you very much. Appreciate your calling. Next speaker, Reva Bennett, is that right?
Chair Perlmutter, we have opposition counsel here, I believe, Mr. Jones.
Yeah.
Okay, so sorry, Mr. Jones, you were here, but you'd never put your hand up. Go ahead.
I was just trying to wait and be cordial to the board and the applicant, but good afternoon. So I'll try to be as brief as possible, but I want to be clear that, and I just want to kind of frame this, that the community, and I represent members of the community, are not opposed to the needs or the fact that these kids need assistance or medical care, okay? We don't want to present the picture that we somehow are against the children. What we are against is the presentation by the applicant that this medical facility, by their own admission in their documentation that I'll try to go over, is some sort of school. There is no charter. I've looked it up on the New York State Board of Education website. There's no charter. If there is one, they need to produce it. They stated that they had one back in 2015, but based upon my review and my research, I have not seen that documentation, and that's their their main way of getting into this community because they know that this medical facility is not permitted as of right in a R1-2 district. We've had this conversation. This has been going on for several years. I wanted to speak to a couple of quick things. I know that we're running a little bit low on time, but I want to speak to a couple of quick things. First, the applicant stated earlier that the collateral loan specifically had to do with the renovation so that they could have this temporary site. In his own submission on page, I believe it's page 2, he states that in short, that these financial arrangements referring to the collateral agreement have nothing to do with the applicant, Ocean Avenue Education Support Incorporated, who is a contract vendor of the premises, nor the Brooklyn School for Medically Frail Children. The future tenant of the premises, these financial arrangements were undertaken as part of a financing structure to renovate and improve the Ditmas Park Care Center at 2107 Ditmas Avenue. Okay, so he stated that it was for the renovation in order to provide this temporary location, but then in his documentation, he says that it has nothing to do with it. We just need transparency here, right? Because to tell you the truth, back in 2012, they filed a certificate of need for the location. This is Ditmas Park Care Center filed a certificate of need that we submitted previously, and they filed a modification, which I don't know if I can share my screen with the board. Let me see if I can share my screen. I'm trying to see. Hold on one second here. I'm having a little bit of trouble sharing my screen, but I submitted the documentation already, and I'll just cite it. I'll just, for purposes of time, I want to make sure that I'm clear. In 2014, the applicant, Ditmas Park Care and Rehabilitation Center issued or requested a project modification in which they proposed that they were going to move the 20-bed pediatric ventilator dependent unit and 1 pediatric respite bed within the nursing home facility. They were going to move it into the main facility, which is the 2107 location. And it states specifically that the applicant previously proposed that the pediatric unit would be located across the street from the facility. So now they're coming and saying, well, we still need this location. However, they filed a certificate of need with the Department of Health, which is indicative of the fact that this is a healthcare facility, not a school, right? And within that modification, they state specifically that they've decided to, this is in 2014, council said that he was working on this in 2012. They stated that they were moving these beds over to the 2107 location. And that's appropriate for these children, right? I think one of the reasons why the applicant is having so much trouble and claiming that it's a unique situation is because this hasn't been done because it is actually, in actuality, a medical facility for particularly vulnerable population, right? So we have a situation in which, they're trying to purport to, or try to say that they are a school, but the truth of the matter is that based on their own documentation, it is not a school. It states very specifically, if you look at the lots that they refer to in their findings, the lots specifically were held by Ditmas Park Care Center. Those lots are being used for a pediatric nursing facility. That's specifically what they state in their certificate of need. So for the board to say that this is somehow not a school, or excuse me, this is somehow not a pediatric nursing facility, it runs contrary to the very documentation that they included in their certificate of need. And specifically, if you look at the case law, the zoning criterion that the board must consider, it says specifically the zoning criterion that the board must consider applies not to the educational institution itself, but to the uses to which the property is put. We are pretty clear, and I think it's very clear, and that's a matter of Bergamo versus Barclay, 77 miscellaneous, 2nd 188, Supreme Court, Suffolk County, 1973. What's clear is that these kids, this population is medically fragile children that need they need to be constantly ventilated because of their respiratory diseases or illnesses. And so to contend that this is somehow not what it is fallacious. The truth of the matter is this has been going on for some time, and we've submitted several documents to the board regarding why the opposition believes that this is a pediatric nursing facility. And in those documentations, it states specifically that it's a pediatric nursing facility. With regard to the issue of, Department of Buildings, for example, they stated that, first of all, we also submitted to the board that a letter from the Department of Buildings that was issued from, I believe it was Patrick Whale of the Department of Buildings, and we submitted this documentation. It says, please be advised, and this is for their application. This is from the Department of Buildings, and it was submitted via email. It says, it was written to the Ditmas Park Association. It says, your letter to Commissioner Chandler regarding application 320-581-1438 at 570 East 21st Street was referred to me for response. Please be advised that this application was disapproved on September 24, 2012. Several objections were shared with the applicant, including that the proposed occupancy is not permitted in the R1 district. A subsequent review by the department's technical affairs unit on November 8, 2013 also resulted in disapproval. The department considered this job abandoned pursuant to section 28-105.7 of the city's administrative code, and the department will not allow it to be reactivated. That's from the Department of Buildings. This is not just the community making this assertion without documentation that seems to that we're just coming up with on a whim. This is from the Department of Buildings, and we have the certificate of need, which indicates that this is something that should not be in this particular community. The board mentioned, I believe one of the chairpersons mentioned that they were concerned, or that the waste there, or it wasn't necessarily what we described it to be. As Ms. Hampton described earlier, the images that I submitted and that were reviewed by medical professionals were of biohazard material. You can see the image of biohazard on there. And as she stated very clearly, if this is how the site is going to be treated before this 23,000 square foot pediatric nursing facility is erected, imagine the waste that will be created after. If you look at the Cornell Doctrine, the board must take into consideration not just the fact that it claims to be a school and give it deference because they claim to be a school, but they have to look into also the public safety and welfare considerations that are associated with erecting such a structure. That's the facts according to Cornell. Now we have this whole issue of the pandemic that requires additional review by the board. We believe that this has been going on.
Mr. Jones, before we continue, because we've read all of your testimony and you've submitted a lot of materials, and I see Mr. Peter Jones' hand up, but we're going to finish one testimony after and then go to the next. Just to make it simpler, right now we're in an unusual situation where they're proposing to set up a temporary, what they're calling a temporary location. That's the ultimate way to be able to test out whether this really is a school, because once it opens and over the X number of years of it operating, ideally to the satisfaction of the Board of Ed, they'll determine whether it's a school. And if they're not persuaded, that's the end of the whole story, because they're not persuaded, right? So what we have ideally, it's an ideal situation where we don't have to be the ones who decide that it's a school yet. It's for the Board of Ed or in the Department of Education to decide based on an actual school at a location that can exist as of right. We don't have any control over that temporary location. And let me just finish with respect to the dumping on the site. My understanding is it's been cleaned. My understanding also is that the Brooklyn School, which is the applicant here, is not the owner of that property. They're not even, which is part of my question, they're not even sort of a lessee vendee, if there's such a thing, a contract lessee, because we haven't seen that contract. So the actual person at fault is Kolel Bais Yaakov. I don't know if anyone in this group is a member of that entity. They're the responsible party, but you can always, because it is a case before the board, you can always come to the board and say, they are not maintaining the site, and because it's a board case, we can go to them and request a compliance hearing, where then we reach out and we send our own compliance officer and the Department of Buildings to do a site inspection, and then a violation will be issued. So it's a different entity that would ultimately own the site. So I don't think it's necessarily fair to judge the future entity against the prior entity. But, and so that's kind of where we are. And I don't really want to debate this. Instead, you can submit additional papers, and I do expect that the applicant's counsel will respond to that. Yeah, just to finish up.
Just to finish up really quickly, and I understand your position in terms of the Department of Education ultimately making the decision in terms of it being a school or not, right? However, in the BSA's findings or issuance of the grant back in 2015, you made a determination that it was a school, and based on that determination, that the variance was to be granted. And our only position is that if anything that we've learned from this testimony today that we can gather is that it's far too early to make any determination. The issuance of the grant should not have been given, because if we have to wait 3, 4, 5 years for the Department of Education to make a determination, then they don't have the right to be in the community as of right as a school, because that determination has not been made.
Understood. Thank you. So I'm going to move on because you're on screen, Mr. Peter Jones. Go ahead. I'm unmuted.
3 minutes.
Yes. Yeah. Hi. Hello, everyone. Good afternoon, Madam Chair. Again, my name is Peter Jones. I'm a former resident of 931 Ocean Avenue, which is directly adjacent to one of the properties in question. Obviously, I have a vested interest in this particular situation. Now, a little bit about me, not going to be very long. I'm an occupational therapist, which is one of the clinicians I believe the applicant has stated in their paperwork that they would need to help to facilitate the treatment of these children. I have over 20 years of experience with treatment of ventilator-dependent individuals. So I also have a special interest in the patient population in question, that being the medically fragile children. Now, that being said, I want to know why is so much emphasis being placed on the scholastic aspect of the proposed facility when the medical needs outweigh the academic needs? Now, yes, these children need and deserve to be educated as well as anyone else, but it should be done in a more appropriate community setting. Let's call it what it is. This is a medical facility with a school-based component. That is why, as Mr. Jones has stated, a CON was needed for the current their current facility. You know, now when the transfer of these kids supposedly happens, whenever that'll be, to the proposed facility, you know, they're still going to need a CON, and they get a CON from the Department of Health, as we all know. Now, the CON determines that it's a long-term care facility that these children are going to be placed in. It's a medical facility. It's not a school. It's a facility with a school-based component. We have to be clear about that. Now, the children are more at risk, I think, from the surrounding environment, with all the external factors that are out of their control. And, you know, basically it's not ethically or environmentally sound or responsible. You know, that, like I said, being a clinician and working with ventilator dependent individuals, you know, that's definitely going to be a problem. That's definitely going to be a problem from a public health aspect. It's going to be a problem from an environmental aspect. The children are, you know, basically they need and they deserve to be educated, but you cannot educate a child that is gasping for air. You cannot educate a child that has severe medical needs. Those needs have to be attended to. And this is going to be more than likely it'll be a long-term care facility with a 24-hour a day, 7-day-a-week medical attendance. Okay, so basically, let's call it what it is. The CON that exists is for where they are right now. They're going to need one for wherever they're going to be. Okay, and if it's going to be a medical facility, it is not zoned for this R1-2 district. And that is all I have to say. We have to call a spade, and that's exactly what it is. It's a medical facility with a school-based component. I wish luck to the applicant in trying to get another location for the facility, because of course the children need to be attended to and educated, but it's just not appropriate in our environment or in our community. Thank you very much.
Thank you. I just want to point out to counsel, Mr. Stephen Jones, that this board grants variances to, for example, hospitals, because the hospitals have an educational component to them. So, so that's very worth checking. Hospitals that are teaching hospitals that have all kinds of elements that are related to education qualify a hospital under the Cornell deference doctrine, and we have many hospitals that have received variances, just to move on. Okay, so then going down the list of people with their hands up, can I move to, who's this person?
Miss Bennett.
Miss Bennett.
Okay, hi, thank you. I'm River Bennett. I live here in the neighborhood, and I oppose the time extension for the variance because it just seems it's not actually being planned as a school, and I'm concerned about plunking down a medical facility in the middle of the residential block. That's my opposition, and it's gone on for a very long time, and I don't quite understand what the missing pieces are because I'm not a lawyer in this. I just live here in the neighborhood.
Thank you very much. We do appreciate you calling in.
Okay, and how do I'll find out how to follow up on this anyway. So thank you.
Okay, thank you.
Okay, fine. Okay,
Well,
bye.
continue to listen and we'll tell you when the next hearing is, okay? Or approximately.
Okay, good, thanks.
Okay, so we're going to allow now someone whose last three digits are 530 to speak, and please state your name.
Hi, good afternoon, Dr. Matthew Jones.
Okay. Go ahead.
Hi,
Relationship to the application?
So I'm actually a former resident of 931 Ocean Avenue, and I'm in opposition to the Brooklyn School of Medically Fragile Children.
Okay, did you want to say anything else?
Yes. Oh, so good afternoon, council members. I wish you continued health and safety in these trying times. As a practicing licensed physician, the justification provided by the Brooklyn School of Medically Fragile Children is very misleading. The primary needs of ventilator-dependent children are to sustain life and maximize the quality of life through infection control practices, administration of medications, quality and nutrition, and providing a semblance of their prior life prior to their healthcare needs. With the submission of the CON to the Department of Health, the current site of these patients it's quite apparent that the primary role of this organization is to serve as a long-term acute care facility. Make no mistake, I understand the need and encourage the formation of a healthcare facility such as this, but it must be done in an appropriately zoned area. The expressed difficulties of identifying the student body reflect the heterogeneity of this patient population. The active pediatric patient vent-dependent population is highly variable and precludes a clear pathway to identify the educational needs and respective tuition. Furthermore, in this current global pandemic we are currently faced with, I must acknowledge that the highest rates of COVID-19 infection are within facilities such as this, and that poses a significant risk to the surrounding residents of the community.
Okay, thank you. Anything else you want to add?
No, that'll be all.
Okay, thank you very much for calling in. Appreciate your call. So then we'll move to someone whose last three digits are 495. Please state your name when you're allowed in.
Hello.
Hi, state your name, please.
Can you hear me? My name is Ray Peebles. I'm a resident of Ditmas Park, and I oppose the project 343 DZ. I'm also an architect, and good evening, everyone. Good morning or afternoon, what time it is. I saw and I've heard some of the statements that Attorney Jones had made, and those were some of the statements I was going to make. But I want to know if everyone understands what a CON is. A CON is issued by the New York State Department of Health, and it's only issued on medical and health facilities. You don't get it issued on a school. Now, from that being said, we have a CON with a number on it of 092036, which has been issued for this particular site at 570 East 21st Street in Brooklyn. And basically, it says that, in writing, and we got this from the FOIL, Freedom of Information Law, and basically what it says, and we forward this to the Board of Standards and Appeals, and basically it says you have two health centers there, one on the second floor and one on the first floor. And the first floor being more of an intense type of care, and the first floor being basically a clinic. Now, as you know, Commissioners, Use Group 3, a community facility, is a hospital or medical facility, but it cannot be placed in R1-2 zone unless it has approval from the City Planning Commission. Now, Use Group 4, which is a clinic, cannot be put in this area at all. Based on that, and then based on information that I've gotten, and I know that the board has from the Department of Buildings, from their technical service, a document number 281084, issued 11/8/2013. Basically, what they're saying is that without previous information as to whether CO was issued, which was not furnished them, the design and intent from an argument from the applicant, they said this is a accessory school to a dormitory use. And actually, they basically recommend, and it's in the facts and findings of applications submitted to your agency, the building department actually recommends that it's a dormitory, and dormitory cannot be used or constructed in this area unless they get a special permit from the Board of Standards and Appeals. And I noticed the Board of Standards and Appeals did not
Mr.
issue a
Peoples, your 3
special
minutes is up. Oh.
Yeah, Mr.
Okay,
Peoples,
let me
just
finish one
ask you,
statement.
I just want to ask you, can you please submit again those materials that you're referring to? I'm not finding them quickly. So if you could resubmit.
I would do it. I just submitted to Carlos Costanzo a few weeks ago, but I'll do it again. It's just one other question I have. When the building department gives out objections so that they can have denial, this allows the applicant to file it at the DOB. And one objection was not faced, and that's the objection of proposed school dormitory, Use Group 3 is not permitted. And I'm reading this, in R1-2 district, and you need a variance from the Board of Standards and Appeals. And that variance was not given because the Board of Standards and Appeals know that if they issue a special permit on this particular project, the project would have to be cut down half its size because the floor area ratio would have to be 0.5, which would cut this building floor area in half. And that is the only way to get a dormitory use in this area. So I don't understand the resolution. I'm totally confused. Thank you very much.
Thank you very much. Appreciate your call. Okay, and we have someone with last 3 digits 750. Please state your name when you can hear us.
Hi, this is Harry Bobbins from Respect Brooklyn. Thanks a lot. A lot of things I agree with from the opposition. I also believe the chair and the commissioners put the issue very succinctly in the beginning, and appreciate the consideration for community input via the new Zoom process that you indicated. That said, it seems, again, the board has been extremely generous with this applicant. The applicant has said they still need many years to get real about this, and this is an extension. This isn't a variance. By denying the extension, the board has not taken a position against this project, which they laud in some ways. The applicant is free at the appropriate time, some years from now, admittedly, to apply for a special permit from the City Planning Commission, to reapply for a variance or some other relevant approval process. Not extending this variance will not kill, if that's a concern, this project in any of its possibly noteworthy aspects. We agree with the applicant that there is no school. We agree with the applicant there are no students, there is no curriculum, there are no teachers. We agree they do not own the property. The board has mentioned the previous authorizations and numerous aspects under the Cornell Doctrine. Here we have a so-called school twice removed. They are not the owner. They are not the lessee, as was pointed out. Do they deserve deference from the Cornell Doctrine for educational, so-called educational institutions? In 2014, the revised November 5th applicant statement indicates on page 7 that they are chartered by the New York State Board of Regents. If they cannot produce a document dated before that date, everything here should be entirely moot, regardless if they are able to produce that. By their own admission, they don't have any of the components of a school, and they are now, 5 years later, with an expired variance, intending to operate in a different location, the medical facility that the community pointed out many, many years ago, and of which the intertwined, murky financial aspects of this project are no less clear than they were prior to the March 2020 submission by the applicant. It's unclear what else the board needs to hear. The applicant can say they're going to go on this or that course of action for the next 1, 3, 5, 10 years. At what point is enough enough? The expiration can expire, and the board can hear it again in the future. The applicant relies on some so-called expert testimony. The HHC Capital Advisory Group, per their own documents on their website, have no school or educational lending experience whatsoever. Instead, there's a list of over a dozen, quote, nursing facilities. This is in our testimony. The other so-called expert firm, Stivright, was the subject of a New York City comptroller audit that found, according to headlines in the New York Post, quote, city audit finds flaws in paid-for services for special needs students, end of quote. So these are the experts the applicant is relying on today before the board. Finally, regardless of the COVID pandemic situation, which is very serious and alone should trigger a renewed environmental assessment, the conditions have changed in the neighborhood significantly since 5 years. Regardless of the applicability of the Cornell Doctrine, environmental and negative impacts should be reevaluated. The neighborhood has undergone different development. There's been a huge expansion across the street of a 200-bed facility at Ditmas Park Care. And this site still, a major component would be a 40-car parking garage, which might be the ultimate need for the healthcare facility across the street. Please do not extend the variance and let them start from scratch. Thank you.
Thank you very much. Appreciate your call in. I don't see anybody else with their hands up. So let's just ask one last time. If anyone would like to speak on this case, please dial *9. That will raise your hand and we'll recognize you. And otherwise, if you're on the Zoom call and you're visible to us, then raise your hand using the, where is that button for the raising hands? On the lower right-hand side of your screen, you can raise a hand. Or just wave your hand if we can see you in the video. And otherwise, we're going to move back to the applicant and ask, oh, Kurt, did you want to say something?
Yes, we have 4 dial-ins that have raised their hand to speak.
Okay, thank you. Sorry, I didn't.
So we'll start with phone number 388. Please state your name and you have 3 minutes.
Yes, my name is Dwight Hampton and I oppose. This is clearly a medical facility and it should not be allowed in our neighborhood. And we've been talking about this for a long time. I mean, I was on site years ago to testify, and then we still, discussing this issue right now. And this is nothing more. This is clearly a medical facility and not a school. And that's all I have.
Thank you very much. I appreciate your calling in. Go ahead, Kurt.
Phone number Mr. Dwight Hampton, please state your name.
No, he already spoke. I named him, so I'm naming the people as they call in. So it'd be the next number is 388.
Yes.
We just did 388, didn't we?
Okay.
Yeah.
Number 160, please state your name.
Hello?
160. Yeah. Go ahead.
Hello.
Yes,
State your
go
name,
ahead.
please.
My name is Dr. Harold Byer.
And I oppose the extension of the variance 343-12-50570 East 21st Street, Brooklyn. I'm a physician. I'm adjacent to the present structure just being discussed, and I've been in this area for 40 years. And as a resident of the area, I think that from the inception, the School for Medically Frail Children has been trying to masquerade as an educational facility, which it can't be with School for Medically Frail Children who require intubation constantly 24/7. And this day of COVID, it's even more important that these children be placed in a better facility over more probably where they are right now, rather than among the community residents, because they're much more susceptible to the COVID. Outside of the COVID, this is not a very prudent area for them to be in, because here we are most retirees, older people within the block, and the construction of the school will disrupt our entire style of life. I've been here for 40 years. I've been practicing medicine in the area for 40 years. And I think that most of the people in the area right now are senior citizens. I don't think that much consideration is being given to those. I think that we need to think of the residents of block, along with the children with the medically frail children with the need for constant intubation, who definitely require a home. And I think that where they are now should be made a permanent home and should be increased rather than coming back into the small area adjacent to our resident right here in Brooklyn. Thank you very much.
Thank you very much for calling. Okay, last three digits, 783.
Yes,
Your
hello.
name?
Yes.
Yes.
Good afternoon. My name is Marilyn Peebles, and I'm a resident of Ditmas Park, and for a very long time. I've been following all the pros and cons of this particular project. I'm not opposed to children that have special needs, but I do think that the residents and the whole community has to all their thoughts and comments need to be taken into consideration and thought of very, seriously. I oppose the time extension of the variance for the 343-12-BZ at 570 East 21st Street, Brooklyn. I wish everyone the best of health and to be safe. And again, I do oppose the variance of this project. Thank you.
Thank you. Thank you very much for calling in. Okay, last call on anybody who wants to speak who has not already spoken by hitting *9 on their phones. Otherwise, we're going to move back to the applicant, and I would just like, and Mr. Hampton already spoke, so his hand is up, so we're gonna leave that down, okay? Okay, so then I'd just like to, my question to the applicant, actually specifically to Ms. Katsev, is to explain what was raised by the community, which is, and we know that a certificate of need is something that hospitals apply for. Could you explain why we keep talking about a certificate of need with respect to this school?
I'm glad you asked me that question. Actually, there are two separate processes. The certificate of need that's issued by the Department of Health has really nothing to do with the Department of Education's requirement that regional need. They don't refer to it as a certificate of need. It's a demonstration of regional need. Are there children in this area at this time who will need this kind of classroom? And if so, how are those children grouped in terms of where is the greatest amount of need? We have information from the health directors of various hospitals that at least 40 children a year, this is from one hospital, from Maimonides, are discharged from the hospitals who, some of them will need long-term care, many others need to simply be in a school where their medical needs can be attended to. And that is a large part of the population that's anticipated. Children who are at home now, they're receiving home instruction, they're with their parents, but they are entitled under law in New York City and throughout the state to only 1 hour per day of home instruction. These children would have an opportunity to be in a school which is very close to a mainstream school. They would have appropriate curriculum and they would then be able to move on to other schools as their medical needs improved. But it is not the same as the medical certificate of need. It's in fact a different word. It's a question, it's called regional need, and it is a requirement of the New York State Education Department before they embark on the process of reviewing an application to find out who are the children who would need it. Are they here now? Will we be able to bring children back from out of state? And that's an important consideration to the Education Department too, because at the last count, there were about 70 New York City children who were out of state. The fee for their tuition is paid by the New York City Department of Education. They're in a nursing home in another place, but they're away from home. They're not being educated in a way that will enable them to move into less restrictive settings. And Department of Education wants to know about who these are and what the needs are before they look at an application. So it is a different concept.
Okay, thank you very much. So what I would like to ask, because it's very late and we are very far behind schedule, I'd like the applicant group to kind of go back to their desks and listen very, very carefully to everything that was said at this hearing and go systematically through everything kind of line by line and make sure that the next submission is responsive to absolutely every statement that was made, so that we don't have us going through this saying, where's the answer to this question? And when I say statement, I mean to include the statements by the community who have raised concerns about the facility and about the management of the site. And you can't just pretend like they didn't raise those concerns. We hear them, and raised other issues that are related to our authority to grant an extension and our authority to have granted the initial grant in the first place. You must respond to those things and not just pretend like they didn't happen, okay? And I don't want to have further debate on this, Mr. Stark. Only if you have a question, please don't make a speech, okay? Go ahead.
You're muted, Mr. Stark. Unmute.
Muted. Okay. You're muted.
Go ahead.
I know we've never done anything like this in the past, but given the number of questions, could it be possible for the applicant team to submit to council a draft set of, I want to make sure we get all the questions.
No. Your job is to go through, just like we do, the hearing. It's work. Yes, it's work. Go through the hearing, listen to what's being said, make notes about what's being said, and make sure you reach out to your various consultants to make sure that they are responding to every single comment. That's your job, not our job, okay? We've been here for a long time. We read all the testimony, we read all the submissions. Your job is to make sure you're responsive to all the issues, okay? Commissioner Shaita, go ahead.
Thank you, Chair. Can we get some sort of a comparison between the currently scheduled program to start at the temporary location versus the originally planned program sizes?
Okay. Yes.
So how many classes, how many students?
Yeah. Oh yeah. Yeah.
Okay.
Thank you.
So right. So obviously we're waiting for the completion of the educational program that will be applying for this new site. We need to see a copy of it. We need, above all, to see a copy of the charter that the Board of Regents, because so far can't find that anywhere in the materials, which I find quite odd given the questions presented. Okay, so I thank everyone who's still listening from the public. I thank everyone for calling in. We really appreciate it. I also want to thank Kurt and Steve and Carlo for figuring out how to work this much better system for testimony. It's much easier to manage, and all the neighbors for calling in and the consultants. And the next time, please bring more consultants, the ones where the questions have to do with development. The person who knows about development needs to be on, and a representative of the property owner, so that they can be here to hear from the community the concerns about how the site is being maintained, et cetera. I mean, read the tea leaves. Don't just go by the line instructions. Do what is the right thing to do for the next hearing. Okay, for the benefit of the public, we're going to,
there's one more
that's another
case.
question. How much time? Yeah, no. How much time do you need to submit
I'm sorry.
on this one?
A couple months at least. I mean,
Yeah,
we would like, we expect a number of things to happen, as Marion noted earlier, in the next month or two. So it would be really great if we can meet sometime in the middle of November. Would be best.
Okay, so for the benefit of the public, the way that it works is based on that request. We'll schedule a hearing sometime, a continued hearing sometime in November. And the way that you find out about it is either you can reach out to the, actually, maybe the best way is to have Mr. Jones, counsel, reach out to our counsel for the assigned date, and perhaps you're in touch with some other members of the public. Otherwise, our revised schedule is mounted in about a week on the Board of Standards and Appeals website. So you can actually scroll down and look in the month of November when that date is. So I don't know if somebody has quick access to the lineup right now.
So the submission date is the 21st, I think. Oh, the 2nd, I'm sorry.
Sorry, the 21st of what, Tony? I don't know what you're referring to.
You're talking about submissions?
No, I'm talking about when, I just don't have a copy. I'm trying to make it easier because we have so many people looking. When is the lineup showing hearings? July, sorry. Nobody's there with it. Sorry, I can't open the Excel spreadsheet. So can somebody out there open up the lineup so that we can say what the dates are?
Are you looking for the combined calendar, Madam Chair?
Yes, I can't open it, so.
Okay, what date are you looking for?
Tell me what the November dates are.
November 9th and 10th with a submission due October 21. And we have November 30th and December 1st with submission due November 12th.
That would be better. We would like.
Okay, so what we're talking about for the community's benefit is a continued hearing on November, what'd you say, 30th and 31st?
No, it's November 30th and December 1st, according to the calendar here.
Yeah, okay, 30th and December 1st. So it'll be on one of those 2 days, and you'll look at our online to see which day we've assigned it to, okay? Sorry for the confusion. It's hard when we're on Zoom to do these things, okay? Thank you everyone for calling in. I just want to say that it's 1:20 and we have a 2 o'clock return call, so return hearing. So what I would like to do, which we did one time before, is give us a break until 2, and then we'll pick up the hearings from where we left off, and hopefully we can move more quickly in the afternoon so that we can finish everything off. And if we can't, we'll decide what to do.
So the last case for the morning, you're going to pick up this afternoon?
Yeah, it's the last case. There's only one other?
Yes,
So
it's the Little Neck Parkway. requested
so,
adjournment,
yeah.
you don't want to request.
Yes.
That's the
so
one you
we'll
didn't
pick
want to
that one
adjourn.
up. Otherwise, we won't have time to have a break, and we've been at this with 3.5 hours straight without stopping. So, okay, so we'll be back at 2 and we'll pick up that case at 2. All right,
Okay.
everyone. Thank you very much,
Thank you
everyone.
very
for
much.
Thank you.
Okay.
Hello? We're live on YouTube?
Yes.
Okay, thanks.
Yeah, Jella?
Hi. Hi. So we are on YouTube. Okay. We're just
Huh?
I just wanted to check if we were on YouTube.
Yeah, but are we starting? Because then at 2 o'clock, we have to leave and go to the other meeting then.
Yeah, that's what.
I mean, I asked Steve, I'm like, is she aware? I was like, what?
So I guess we'll finish this application, the 10 a.m. session, the third application, and then go to the next hearing.
But it's in 9 minutes to 2 o'clock. So how are you going to do that
Yeah.
if we have to go to the other meeting? We're going to drop out of, are we going to drop out of this?
I don't know.
I think we're gonna make an announcement.
I don't know. What happened?
I think we're gonna make an announcement.
I don't know. Because then we have to drop out and go come back in the 2 o'clock.
I find this confusing. Once I almost missed it.
Yeah, well, now after 2 o'clock, well, I don't know, we're going to stay in here. I asked Steve, I don't know. I mean, we stay in here and then we go back out and have to log back in on the 2 o'clock.
Yeah.
Because
I
that's
guess
a different
so. I
meeting
think so.
ID
It has
number.
to be. It has to be because it has a different number, right? So
Has a different ID number.
Yeah. So once this is done, we get out of it and log in immediately to the next one.
That's correct.
Because it says you're on break shortly, so. I think once it hits 2 o'clock, we should log out and go back to the next meeting. I'm tired. Waiting for Kurt to respond. Somebody answers the damn phone. Hey, a quick question. Are we leaving this meeting at 2 o'clock and logging into the 2 p.m.?
You're trying to get in too, right?
I'm still sitting here where it says break shortly. You know, we're sitting here, Shonda, Jill and I, but I'm saying, I emailed Kurt because it's almost 2 o'clock. So do we leave this and then go back into the, go?
That's what I did. I logged in new.
But I see the chair. I can't hear her.
Hit the 2 o'clock?
Yeah.
Hit the 2 o'clock. I don't know. This is what Carlos saying, Jilla. Hit the 2 o'clock.
But Marjorie is
break the
on.
hearing, resume
I see
shortly.
her.
I did the, I went on the 1 o'clock. I went on the 2 o'clock and it said another meeting in progress. So I think you have to hit on the 1 o'clock. I see Marjorie, but she's muted.
So are we staying here? We're staying here?
Does the applicant
No,
have
Marjorie
the
seems to be
later
saying
one?
no. Hold on, let me call Marjorie and.
I can't answer. Can you hear me?
Yeah, we can hear you.
Oh, now you can hear me. So I couldn't unmute myself. I can't control anything now.
So go to the 2 o'clock session, Carla was saying.
Okay.
So we're
All
getting
right,
off
so
this?
let me leave this and go back.
Okay.
Does the applicant have the link to that?
All right, so let me leave this meeting. Let me leave this meeting, right, the 1 o'clock? Leave it? Okay.
Hey, I have a question. Does the applicant have the link to the second hearing?
I think it's.
We don't know.
It's on the lineup, right?
We'll have to figure it out because we can't get on and I can't get on either.
Right, because the applicant and the public has been notified for the AM one, right?
It doesn't matter. We can't continue it. It's discontinued. It's not
Okay.
working.
Okay,
It's
all
not
right.
working.
Okay,
I can't control
all right.
anything on it.
Okay, all right.
Okay, so we're going to the other one.
Yeah, I can't seem to get on it either, but.
Okay, so we have to go to the 2 o'clock one. Okay.
Yeah. Hello? Okay. Are we now in here? Hello? You hear me? Somebody hear me?
Hello?
Yeah, we're live?
Looks like it.
Oh,
This is the AM session still in, right?
Hi,
we're
everybody.
still in the AM session then. I don't know. I just told Marjorie to go to the 2 o'clock. Because Carlos said go to the 2 o'clock.
Yeah, that's what I tried to do, but it said another session is active and wouldn't let me into it.
We just talked
Have
to
one
Steve.
more case